Good morning, folks. It is Friday, August 13th, and this is the Colorado Oil and Gas Conservation Commission, and this is our continuation of enforcement hearing involving KPK, and we are going to take the roll call to initiate this matter. Ms. Larson.
Thank you, Mr. Chair.
Whoops. Is that me?
Is this better?
I didn't. Yeah, I don't have my audio connected.
I don't know. Is this better?
That's better.
Commissioner Bowe. No. Commissioner Gonzalez. No.
I don't think
they can hear you now.
No one can hear you. Bear with, folks. We've got a little audio problem here.
Oh, you have to use one of those microphones. It doesn't.
Apologies. Commissioner Bogue. Commissioner Gonzalez.
Here.
Commissioner Hackett. Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Very good. All right, then. Let's go ahead and advance Mr. Jacobs and Mr. Mueller to the panel. I see we have Ms. Rosenberg and Ms. Stafford. Give us just a second, gentlemen, and we'll get you on board. Okay, let me preface the order of business today, and then I'm going to make sure that the attorneys are in agreement. I believe that we are going to start with oral argument on the statute of limitations, and that each party will have 5 minutes for said oral argument. We'll start with KPK, and then we'll follow with staff. Following oral argument, commissioners have an opportunity for questions, which does not count toward the 5 minutes for either party. We then will move to closing statement by KPK of 15 minutes and closing statement by staff of 15 minutes, followed by, again, the potential for questions from commissioners, which would not count toward either of the 15-minute time allocations. At that point, we do have reserved an opportunity for executive session with our attorney. And then if we do an executive session, following executive session, we would take no further business and we would adjourn. We would return on Monday, August 16th at 9:30 for deliberations by commissioners. I'm not planning on closing the record until we get close to finalization of deliberations. And I have informed parties that they should attempt to ensure witnesses remain available in case questions arise either today or Monday during deliberations. That is my summary of the process that's before us today and Monday. Does any commissioner have any question regarding that? Did I get it right? And then with regard to hearing from Ms. Stafford and Mr. Jacobs or Mr. Mueller, is everyone comfortable that we've adequately set forth what we're going to be doing today? Ms. Stafford?
Thank you, Chair Robbins. I thought you were talking to the commissioners first, so I was going to let them go.
I glossed over them. Nobody raised their hand, so I think I probably summarized what we're going to do. So
understood. I think staff is in agreement with your with your schedule, and that was our understanding of what would be taking place going forward.
Mr. Jacobs?
Yes, I believe that the schedule is as we've expected, but I do believe Mr. Mueller has a clarifying question to raise.
Mr. Mueller?
Yeah, I think we're fine with the schedule as you outlined it, Mr. Chairman. There is one sort of housekeeping matter that I would propose is best taken up before you start the oral argument on statute of limitations, but can do it at any time, but there is one housekeeping item.
Okay, I have one housekeeping item as well, so let me go with mine first, and then we can touch base with yours. Last night, I don't know, about 9 o'clock, the commissioners received an email from Gary Haladke. Not sure if I know how to pronounce that last name. That email has been forwarded to Ms. Larson. Ms. Larson will forward it to the attorneys for both sides. We are not going to make that email part of the record, nor will commissioners be considering the substance of the email in their deliberations. So that's my housekeeping matter. Mr. Mueller, go ahead and let's hear yours.
I think we came to a nice resolution yesterday that everybody understood about how we would treat the exhibits that are in the record. And there, as to those that were objected to on the basis of just foundation, we agreed to let those be part of the record. Those that were separately objected to on a different basis are not in the record. And I think everybody's in alignment with that. However, there is one exhibit that's been referred to sort of off and on a daily basis throughout these proceedings that we think ought to be in the record. It's technically objected to, and therefore, per the rule we came up with yesterday, it's not in the record. We would like to clarify that and ensure that it is admitted to the record. The exhibit is LLL, Respondents Exhibit Lll, that was referred to by Mr. Lucas Satterley routinely as he did his summations. I think we put it up on the screen a couple of times just to expedite his presentation. We directed the commission's attention to that exhibit, and we think it ought to be in the record. It's objected to, but I think the basis of the objection, Ms. Stafford might review that, probably is not appropriate in as much as LLL is no longer a settlement communication. It's an attachment to our pre-hearing exhibit, and it doesn't contain settlement material. So that's my housekeeping item. We'd like to clarify that LLL can be part of the official record.
Ms. Stafford?
Commissioner Robbins. Yes, thank you. Well, we object to that approach, and furthermore, a lawyer referring to an exhibit is nothing at all like a witness laying foundation and getting an exhibit admitted into the record. What we had was a lawyer referring to a document. We maintain our objection. There was no motion to move it into the record, nor was there a witness who even discussed that document. So that was actually one of the documents I was specifically thinking of yesterday when I clarified that the documents for which there were objections beyond just foundation, those had not been moved to be admitted into the record. But even if it had been, a lawyer can't, in a closing, admit a document into the record as evidence.
Thank you, Ms. Rosenberg. I'm going to allow it in as a admitted document. I categorize it, frankly, more as a pleading. It really is something that is illustrative and informational to commissioners. I know I've looked at it. I plan on looking at it again. So LLL will be considered part of the record. Any further housekeeping matters from either side at this point?
Not from respondent, Your Honor.
And not from staff, Chair Robbins.
Okay, thank you. At this point, I'm not sure whether Mr. Jacobs or Mr. Mueller is going to argue the statute of limitations, but whomever is going to do so, your 5 minutes will start when you start speaking.
No action or other proceeding based upon a violation of this article or any rule, regulation, or order of the Commission shall be commenced or maintained unless it has been commenced within 1 year from the date of the alleged violation. That is the text of the Oil and Gas Conservation Act applicable to staff's enforcement actions for alleged violations at 2 NOAB locations you've heard about in the last few days. The statute, CRS 346115, is not ambiguous. Any action must be commenced within 1 year from the date of the alleged violation. This provision was not altered by recent revisions to the Act or by the General Assembly through passage of Senate Bill 2019-181 to revise the Commission's penalty assessment authority. It remains unchanged, a 1-year statute of limitations, which is a threshold legal determination and has nothing to do with the merits or weight of evidence regarding the alleged violations. If the notice of alleged violation was not timely served, it cannot be enforced. It is also clear, pursuant to Commission Rule 523, that service of an NOAB constitutes enforcement of an action for statute of limitations purposes. And to be clear, whether an action has been commenced within 1 year is entirely unrelated to how staff calculates penalties. Staff cannot impose any penalties on alleged violations if the notice of alleged violation was not issued within a year. So let's review the relevant facts of the affected NOABs for the NESU 1 flow line and the NESU consolidated flow line. For NESU 1, 2 alleged violation dates and NOAB service dates are that staff alleged a violation on November 30, 2019, which is the deadline the Commission set for a closure request or a Form 27 work plan. The NOAB was served on December 10, 2020, over 1 year after the date of the alleged Rule 901C violation. The text of the NOAB itself identifies November 13, 2019 as the date of the alleged violation, which is when the Commission inspected the location and allegedly observed that no BMPs were in place to minimize runoff from the excavated soils. Yet the NOAB was served on December 10, 2020, over 1 year after the alleged Rule 907A violation. For the NESU consolidated flow line, the alleged violation and NOAB service dates related to failure to report derived from the date of the notice of soil staining by the tenant farmer to KPK. Under Rule 906B1A, staff alleged 3 violations that correspond with 3 related deadlines for spill reporting. And while the NOAB identifies January 13, 2020 as the date of violation, the appropriate dates of alleged violation are November 2nd, 24 hours after the landowner notified respondent of an alleged spill, November 4th of a spill, November 4th, 72 hours after such landowner notice, and November 11th, 10 days after such landowner notice. The NOAB was served on January 12, 2021, over 1 year after these November 2019 dates. And therefore, these alleged violations are time barred as a matter of law. Staff relies on an argument that the alleged violations constitute a continuing violation based on a doctrine whose applicability has been highly scrutinized by legislatures and the courts, including courts in Colorado that have rejected its application in other environmental enforcement actions. That doctrine cannot be employed to circumvent the applicable statute of limitations unless it satisfies 2 criteria. The Act must explicitly state that violations of COGCC rules constitute continuing violations for the purpose of tolling the statutory limitations period, and the violations must be ones that the legislature assuredly intended should be treated as continuing specifically for statute of limitations purposes. Neither of these criteria are satisfied here. Staff has departed from the clear intent of the General Assembly, and staff's willingness to chop off dates that occurred outside the 1 year period for purposes of calculating penalties is entirely unrelated to the foundational issue of whether staff can bring the enforcement action at all. Please refer to our motion for partial summary judgment and our response to staff's pre-hearing statement for a more detailed analysis and citations to relevant authority, including the United States Supreme Court and Colorado Supreme Court authority. In short, as a matter of law and not discretion, the NOABs were served more than 1 year after the date of the alleged violations. Number 402-50681, the NESU 1 flow line, and number 402-548-397, the NESU consolidated flow line, and are time barred and therefore cannot be enforced. Thank you very much.
Thank you, Mr. Jacobs. Let's hear from staff, and then we will see whether commissioners have questions. I think that's a better way. Do you have a thought on that, Mr. AAG Davenport?
That sounds fine to me, Mr. Chair.
Okay, let's process it that way. So, Ms. Stafford, if you're going to be undertaking this argument, we would like to hear from you.
Thank you, Chair Robbins. The statute of limitations does not begin to run so long as the illegal conduct continues under the equitable doctrine of continuing violations. In other words, when there is a continuous legal duty to perform an act by an oil and gas operator, the doctrine of continuing violations creates an exemption to the statute of limitations. KPK's violations of the rules continued as long as the violations could be corrected by subsequent action. Now, if you read KPK's argument out of context, I'm sure it sounds appealing. But the Oil and Gas Act imposes continuing obligations on operators, such as KPK, in the state of Colorado. And these continuing obligations are encompassed by the corrective action requirements and conditions of approval we've discussed throughout this matter. For example, KPK has an obligation to notify the agency of spills. That notification is due 24 hours following the spill, and there are other reporting requirements that follow. For each day that KPK both fails to provide notification or submit the proper documentation, they are in violation of the rule. Here, the violation can only be cured by submittal of the missing notification form. The Oil and Gas Act authorizes daily penalties, quote, for each act of violation per day that such violation continues. That's section 121. By expressly contemplating daily penalties for a violation, the statute clearly incorporates the doctrine of continuing violations. Both Colorado, state, and federal courts have held that similar statutory schemes, which include daily penalties, indicates a legislative intent for violations to be continuing. In interpreting statutes, the court's primary task is to determine and give effect to the intent of the General Assembly. To discern legislative intent, the court looks to the language of the statute itself, presuming that the legislature did not use that language idly, and that the legislature intended a just and reasonable result that favors the public interest over any private interest. Agencies possess implied and incidental powers, filling the gaps between express powers to effectuate their mandates. Thus, the lawful delegation of power to an administrative agency carries with it the authority to do whatever is reasonable to fulfill its duties. Now, the legislative purpose of the Oil and Gas Act is to regulate responsible, balanced oil and gas development in a manner consistent with protection of public health, safety, welfare, the environment, and wildlife resources. In the provision regarding violations, the General Assembly declared that the purposes of the section were to deter noncompliance and to encourage any out-of-compliance operators to come into compliance as soon as possible. The Commission should not reduce the number of days for which a penalty is assessed below that number which the evidence supports, and that's in section 121. The equitable considerations of the doctrine of continuing violations include the specific facts of the case, whether the claim seeks to protect a public interest, the purpose and legislative history of the underlying statute, and the rules of statutory interpretation in the civil context. Courts have applied and interpreted the doctrine more broadly in environmental cases than in other areas of the law. For example, courts confronted with the issue of illegal fill in navigable waters have not hesitated to apply the doctrine of continuing violations because, quote, it is not the physical act of discharging dredge waste itself that leads to the injury, but the consequences of the discharge in terms of lasting environmental degradation. Staff urges this commission to reject KPK's meritless statute of limitations argument. Effective enforcement of environmental regulations that were enacted to protect the public health, safety, welfare, the environment, and wildlife resources are based on the theory of deterrence, which operates on three levels: deterring the regulated community from violating the law in the first place, deterring specific violators from further violations, and deterring the public from violating other laws. KPK's statute of limitations creates absolutely absurd policy results, fails to include equity implications, and ignores the well-established doctrine of continuing violations, and is simply an incorrect interpretation of statute and law. Thank you.
Thank you, Ms. Stafford. So thanks to both parties for their oral argument on the statute of limitations. Remind commissioners that we also have the written motion as well as response before us. At this time, do any commissioners have questions for either party relevant to the statute of limitations issue? Commissioner Gonzalez.
Thank you, Chair. I've got a question about basically kind of the violation date versus the discovery date, and I'm going to pose this question to KPK's counsel. And I'm wondering, is it counsel's opinion on KPK that if an operator committed a violation and there was no reason for the agency to have cause to discover that violation other than the operator's self-reporting, the operator didn't self-report, the agency didn't discover the violation for after a year, that operator should be off the hook for that violation?
It's an excellent question. Accrual and discovery are concepts, as you know, that trigger the running of a statutory limitations period. But we're talking about dates of violation alleged by staff that caused the running of the statute in this circumstance, especially in the NESU consolidated case, I believe. There's no question about knowledge or discovery in the NESU 1 situation, as that was the subject of prompt reporting. And then staff came out and alleged a failure to implement BMPs surrounding excavated soil at NESU 1. Those are the operative dates that occurred more than a year after, or before, excuse me, the NOAB was served. So that's the point on NESU 1. I hope I've answered your question.
Well, you did for NESU 1. I was actually thinking about this question specifically into the NESU consolidated scenario. Do you care to address that one?
I'm happy to address that. I think that there may be an issue there with respect to NESU consolidated. However, the staff has alleged those earlier violations. Excuse me. The inspection took place, what I believe, January 14. So, but those alleged violations relate back to the November dates that I outlined in my argument. So we would argue that, in fact, the November dates started the clock. But I understand your question.
That's all I've got, Madam Chair. I'll let someone follow up. I may come back to that.
Thank you.
Commissioner Messner.
Thank you, Mr. Chair. Give me just a second here to pull my notes up. So this is a question for staff. Does staff agree with KPK that Commission must find in the Act legislative intent for violations to be continuing violations?
Commissioner Messner, I believe that was included in the argument that I just gave you. There is legislative intent within the Act that allows for these violations to be considered continuing.
Okay.
Mr. Commissioner, might I address that point as well, or?
Sure.
Thank you. with your permission. Section 121 was cited by Ms. Stafford. That section does allow for continuing violations to be considered for penalty calculation purposes. That is different than statute of limitations purposes. Staff's position renders the statute of limitations meaningless, which violates the legislative intent.
Thank you, Mr. Jacobs.
Thank you.
Further questions, Commissioner Messner?
No, I'm gonna hold out for a second because my notes are unclear right here. Sorry.
Commissioner Gonzalez?
Thank you, Mr. Chair. Thanks for coming back to me. My notes are kind of scattered as well, so I'm trying to find the right spots. Mr. Jacobs, you cited in your motion for partial summary judgment, it's a citation, right? So your citation doesn't necessarily matter. That's where it came from, but it was for 3460 121 subpart 1C Roman numeral 1B. Specifies that a violation begins on the date a violation was discovered or should have been discovered. My question is, by who?
That's 121.
Correct.
And it is the penalty calculation provision of the Act, not the statute of limitations provision of the Act.
Correct,
So
but it goes to the beginning of a violation.
The beginning of a violation is typically this knew or should have known or discovery. In a variety of statutory contexts, whether it's a regulation or a tort. So that accrual concept is what's reflected in that language you just read for penalty calculation purposes. That's 121.
So, and I understand that's kind of the language in which it's written, and we're trying to understand all the language together and understand legislative intent here. And so what I'm trying to understand is, yes, it says for calculation of penalties, it goes back to when a violation is discovered or should have been discovered through reasonable care. And again, my question is, discovered by who?
Well, the person bringing the action. It would be a tort action in the case of an injury, a slip and fall. It would be the regulator in the case of enforcement action. In this case, that's the regulator's discovery or knowledge.
Sure. So in this case, in terms of, even if we're just limiting it to this provision goes to calculation of penalties, that it is that violation begins on the date that staff knows or discovered or should have discovered the reasonable care. Is that your position? Am I right here?
I believe that is correct with respect to 121 concerning penalty calculations. I do not agree that necessarily affects the start of the clock under 115, which is our statute of limitations provision. But thank you for the question.
Sure. Thank you, Mr. Jacobs.
Sure.
But Mr. Jacobs, does that not also render the statute of limitations meaningless if you run with that hypothetical, in that the operator would be incentivized to hide violations and disallow staff from finding out about violations? And so isn't it true that it makes more sense, if we're trying to read sense into the statute of limitations, that the statute of limitations runs from the time that staff reasonably should have learned about the violation?
Mr. Chairman, appreciate your question. The policy, policy concern you've raised is understandable. We're talking about, in the NESU consolidated case, a question of reportability. Staff has alleged that these violations occurred because the incident should have been reported. They relate back from the date of when it should have been reported, and it was notified by the landowner to KPK to the 24-hour, 72-hour, 10-day deadlines. So they're the ones alleging the violation. We maintain it wasn't even reportable, hence the entire violation goes away. But for statute of limitation purposes, if they're going to relate back to those dates, I think the clock has to start. I realize that doesn't entirely answer your question, but there's no intent here to avoid a running of the statute or to hide anything. It's a question of reportability.
Okay, thank you. Similar difficult question for staff. Staff, my question for you is if the violation is that you need to report information by a date certain, right? And that's some of the things that are before us. And you don't report by a date certain, how can you fix that? Like if you had to report by September 1st and you didn't report by September 1st, how do you fix that by reporting on September 3rd?
Mayor Robbins, the only way, especially with respect to the 906B violations, I believe that Mr. Jacobs is talking about with NESU Consolidated. It's staff's position here that the only way to correct this particular violation is to submit the forms that they are required to submit. And if they are late in submitting those forms, then they have violated that rule until the date they have submitted the form.
But if they submit the form 4 days after it was supposed to have been submitted, they're still in violation because they didn't submit it on the day that it was due, right?
They are, but there is an attempt to correct, I guess is what I'm trying to get at. There's an attempt to submit the information that was required, even though it was late.
Okay. Commissioner Gonzalez?
I'm sorry. I was wondering if I could briefly.
In fact, I'll give you a chance to
Okay, thank you.
weigh in on that question. Ms. Stafford, if you wanted to weigh in on the question I had for Mr. Jacobs, we'll give you that opportunity as well. Go ahead, Mr. Jacobs, you're up.
Well, my only point was that the problem is easily cured as well, and that is to simply serve your NOAVs sooner. I mean, staff has to be accountable to this 1 year period too, or it's meaningless on that end.
Ms. Stafford, did you want to weigh in on the previous question to Mr. Jacobs?
Not on the previous question to Mr. Jacobs, but I guess at the comment that he just directed at staff.
Go ahead.
I think it's fairly well known that it does take some time to get an NOAV issued. There is a delay between the discovery and the NOAV issuance, and we have acknowledged that. This is part of the enforcement process. What Mr. Jacobs fails to acknowledge is that there is a particular period where the operator can correct a particular compliance issue, and then an NOAV is really only issued once that operator continues to fail to comply. Regulators need to have this ability to use their discretion to determine when it is proper to issue an NOAV. It can't be a snap decision judgment. And sometimes it takes a little bit more time than maybe staff even feels comfortable with. But I mean, unfortunately, that is sort of the way that we need to figure out if we have the reasonable cause to allege a violation.
Thank you, Ms. Stafford. Commissioner Gonzalez, I believe you were next.
Thank you, Chair Robbins. Yeah, I wanted to follow up on that question. I mean, on the previous question, this is for staff. And, you made a comment about bringing a form, saying a form in past the deadline is an attempt to correct. My question is, can you correct a missed deadline? You miss a deadline, that deadline's still missed no matter when you submit it. And the miss of the deadline, as I understand it, is the violation.
I think it is, but I think it also goes back to this discussion that we were having with some of our witnesses about the continuing discussion that the inspectors are looking to see from operators, and that staff is looking for information here. If the operator attempts to correct this this notification issue, we're looking at that as, okay, well, there was an attempt to correct, provide staff with information there. And I do understand your point of what you're saying is that the missed deadline is the missed deadline, but until they submit that form, we don't have the information that we need in order to have the violation corrected. And we can choose not to enforce at that point too. There's a lot of discretion that goes into whether these NOAVs are issued or not. And here, we have an issue with an operator who continuously fails to report spills to the agency. And that's why staff chose to enforce here.
And then in the case for the, outside of the reporting of the spills, right, and we kind of talked about that discovery date prior, here, in this case, what I'm talking about are form submission deadlines, right? And the forms submitted, the forms not submitted, the deadline's missed, then the forms later submitted, then later the NOAV is issued, right? Still, and then that NOAV is issued outside of a year from the missed deadline from the form, as I understand it, right? So that form deadline is something within staff's control to know, to put some timing around. And then even after it was brought into compliance, if we will, right, even if after there was an attempt to correct, staff still issued an NOAV that was after the date of that missed deadline. And I'm just trying to understand, how do you reconcile that with I guess with the amount of time needed to decide on and issue that NOAV when you've kind of gone through everything and it was really a matter of deadline, missed deadline, late form, NOAV.
Sure, and I'll get in. Hopefully, I can give you the answer that you're looking for here. When staff is looking to or is deciding whether or not to issue an NOAV, it's not just the alleged violations that are ultimately included in the NOAV. There are a host of other considerations that come into play, and it takes time to determine whether or not those are, we can support those with the reasonable cause that I referred to before. Whether, there are a bunch of different considerations that come into play here. And I guess in that respect, what I'm trying to say is that, in some cases, yes, particularly for the, this reporting violation that Mr. Jacobs has focused on, yes, in that NOAV, there were, there's the violation of Rule 906B, and then there's the violation of Rule 901C, which was also for failure to submit additional documentation. And I guess what I'm saying there is that's not the whole story. There are a host of other observations that might have occurred at the site, and it takes time to figure out, what we have the evidence to support in order to allege the violation.
Might I respond, Mr. Chairman? I'm sorry.
Yes, Mr. Jacobs.
Well, the respondent's got 24 hours or 72 hours or 10 days. The staff has an entire year. This is not a snap decision. And that door's got to swing both ways. I mean, they get subjectivity and discretion. But my point in the argument was the statute of limitations is not a matter of discretion. It's a matter of, getting it filed in the proper time or not. Otherwise, it's time barred. That's because of the separation between sections 115 and 121 in the Act.
Could I respond, please?
Yes, please.
I think for a lot of this argument, Mr. Jacobs would have you read the statute piece by piece. It needs to be read all together to determine the intent, the legislative intent. And that's, I think, what we're trying to get at here. And with respect to form filing, it's not just the due date, it's each subsequent date until it's filed. And the statute of limitations only starts to run once it's filed.
Thank you, Ms. Stafford. Commissioner Messner, I believe, has a question.
Thank you, Mr. Chair. So following up on this a little bit, and just I'd like to get both parties' thoughts on this. I've read the case law that each of the parties provided. Some of the case law talks about statute of limitations normally begin to run when the crime is complete. Some of this case law talks about instantaneous events. As we're looking at the COGCC rules, and particularly around the forms, I'm curious as to each party's thoughts around if an initial form is not filed, and then at some point, 3 months later, that form is finally filed. But then based on information that was provided on this form that took 3 months to file, there was required supplemental form to be filed. that form was not filed on time or in a timely manner. Are those unique and distinct violations, the lack to file the supplemental form versus the lack to file the initial form?
I'm happy to
Stafford?
address that. Mr. Chairman, Commissioner Messner. Let's do that in the context of NESU Consolidated. I mean, I think it's all one obligation if it's a reportability question, because no form is necessary if it's not reportable. So these subsequent deadlines are all subsumed within the alleged violation of failure to report. And the clock would start with the point at which a failure to report was alleged as a violation.
Sure, but there are instances where there could have been a determination that a form, that there was a violation, an initial violation, and there was a form that was required to be submitted. And in that case, there could also be supplemental forms that would be required to be submitted. I'm asking if the requirement to submit the initial form and the supplemental form are two different, distinct violations.
I guess it depends on the nature of the request being made for the form. And this is problematic in the COGCC's regulatory scheme because of so much discretion on the part of staff to set these deadlines in the field at various times. If they all relate to the same violation, we take the position that that violation is subject to a statutory limitations period clock. I think that certainly for 121 purposes, where that was amended as a result of Senate Bill 181, the staff now has authority to consider continuing violations of those deadlines, if you will, for penalty calculation purposes. That is unusual in my experience. In most statutory programs, the failure to file a form on the date required is a one-day violation. Even a Clean Air Act operating permit application due 12 months after you become a major source, all the federal circuit courts in the land say that's a one-day violation. You missed the deadline. There are other consequences that flow from that, but not multiple days of violation. So we're in a different space with respect to 121 because the staff has been authorized to calculate penalty.
But I'm not really talking about penalty calculations. I'm talking about instantaneous events, instantaneous violations, specific, unique, distinct violations of the rules themselves, right?
If it's a separate type of form for a different purpose and staff requests it, I guess that does start a clock in and of itself.
Okay.
That is my best effort to marry up COGCC staff's discretion to set those deadlines and the application of a one-year limitations period, Mr. Commissioner.
Okay, thank you.
You're welcome.
Stafford, do you care to weigh in?
Thank you, Chair Robbins. I guess what I would just say is that I think Commissioner Messner's question initially went to whether these were distinct obligations. I just want to make sure, is that right?
Mm-hmm.
So yes, in the case of 906B in the NESU consolidated matter, yes, it's staff's position there were distinct obligations under the rule, but we had consolidated for penalty purposes. You know, these forms are distinct, the subparts are different. And these forms are the dialogue that we've been talking about the last few days. This is important for staff's ability to regulate, and it's easily corrected with a call to the local environmental protection specialist or a submission of the form.
Okay.
If I might.
Then I think that I've got what I need on that. I do have another question though on a date consideration, and I think it was initially brought up by Commissioner Gonzalez. So if we've got a date, this date of discovery, right? So the date of discovery is what I'm asking about. And I mean, there is no question then when staff shows up on site with a staff inspection and there's a date of discovery, they've documented it. There's no question. It's a staff inspection. But then you've got, you know, these other considerations that perhaps this started sooner. And I'm talking generally speaking as far as date of discovery. So I'm not specifically talking about penalties or violation, just generally. I've heard from both parties that, you know, anything prior to the date staff was there could be considered hearsay. So is it fair to say that the clear, defined, no question date of discovery in a lot of these allegations is the date that staff showed up and clearly documented what they saw on the ground in that particular situation, versus the hearsay that maybe this happened earlier, maybe this didn't happen earlier, not exactly sure when the date was, little gray over here. I'd like to hear both parties' thoughts on that.
Sure, Commissioner Mesner, if I could take that one first. You know, I think in a lot of these instances, no, that, you know, KPK has admitted to these prior dates as being the date on which this occurred. But I think there are some other situations perhaps that, you know, if we don't have any information, if KPK had not admitted to the prior date, then, you know, I think that you could interpret that the date that staff went out there and saw what was happening was a start date.
May I respond? Thank you. Concerning the reference to hearsay, Mr. Commissioner, I think we need to be careful to distinguish between witness testimony and public comment or complaint when the complainant or commenter has not been called as a witness, and that's an important evidentiary distinction. So you can weigh the evidence and the weight of testimony of witnesses listed, called, examined, cross-examined, but you should not be considering hearsay because it's been excluded. So I do take exception to sort of lumping it all together and saying, you know, there's some uncertainty. That's your job, to weigh the evidence, and that's through testimony and exhibits as appropriate. In the case of Nesu Consolidated, we have witness testimony that the tenant farmer walked over and spoke to our employees at the Nesu 1 location nearby, and that was on November 1st.
Follow up, Commissioner Messner?
No, I think that's good for right now.
Okay. Any further questions? Commissioner McGowan.
Thank you, Mr. Chair. So sorry, I'm kind of all over the place here. To follow up on this particular conversation, even though the landowner, and there's testimony that the landowner went to go talk to KPK staff, our staff did not know about that conversation and did not find out about that conversation until they went out to inspect based on the landowner complaint. So does that change the date of discovery? Our staff didn't know about it until they went out later, regardless of when the landowner went to talk to KPK staff, because they did not share that information with our staff.
I would submit, if I may, Commissioner, that because this is a reportability issue, there was no obligation to notify the staff. Mr. Latke could have notified the staff. We were working with him, but it was not a reportable spill. Staff has alleged violations in November. If they're going to do that, we believe that the clock should start then.
Okay, thank you. So, Mr. Chair.
Go ahead.
Can I go back to the idea of potentially a differentiation between being able to correct a form submittal versus a continuing environmental or health violation that can be corrected and correctable? If we assume that the form can only be corrected once on the date that it was not filed timely, And the staff then says, okay, I asked for this Form 27 on this date and I didn't get it. So now I'm going back to you and I'm saying, I still need a Form 27 and I'm giving you a new date. And that date then is now, but it doesn't, the form does not appear on the new date. Is that a new and separate violation and date that was not met and it's a new start time then?
I do not believe that is the case, and that is KPK's position, Commissioner McGowan. It's the same issue of the alleged violation and the purpose of the filing of the form. The fact that another date has been provided doesn't breathe new life into or reset the clock. So if it's the same matter, I'll use the BMPs at NESU 1. That is the issue. It was the issue from the start. The alleged violation dates relate to the alleged inadequacy or lack of BMPs around excavated soil piles. The fact that staff asks again or resets the date doesn't stop the clock on that. They need to serve an NOAV within a year, period. Otherwise, 115 means nothing under the Act. They could just reset dates again and again and again otherwise, and that defeats the intent of the legislature that these things be timely prosecuted.
Ms. Stafford?
Thank you, Chair Robbins. Commissioner McGowan, to answer your question from staff's perspective, I think, I think arguably, yes, it would be though a case by case basis. And, I think there's a situation there where with what I understand you to have said, the Form 27 does not get it submitted on the date. We go back to the operator and we ask, we need this information. Here's a new date to submit it, and they still don't do it. Am I understanding you correctly?
Yes, was that a new and different violation then?
A new and different violation. So I think it would be based on a case-by-case basis. Like I said, this is a particular corrective action that staff is applying to a particular case. I'm assuming in this case, the NOAV has not yet been issued and we're trying to just have the dialogue with the operator. Is that right?
Yes.
Okay. So in that case, I would say that we could issue a new corrective action, and I think that would start the clock again.
Because that new requirement, that new corrective action is correctable. There's a new date for you to meet. There's a new bar for you to jump over, and you can correct it and you can meet it.
And this is prior to the issuance of any sort of NOAV, then yes.
Thank you.
Might I briefly respond? I just want to clarify, at least with respect to NESU Consolidated, we're only arguing about or asserting the statute of limitations for purposes of the missed reporting deadlines. Any subsequent forms 27, that is not at issue in our motion for partial summary judgment with respect to NESU Consolidated. So I want to clarify that these questions and answers about form submittals and is that continuing violation or a one-day violation, and can another request for form submittal or deadline give rise to another clock starting, that does not relate to NESU Consolidated. And I hope that's clear.
I would just like to clarify that I understood Commissioner McGowan's question to be more of a hypothetical and to be walking through, her understanding of what could happen. So I will make that clear record as well.
Thank you.
Okay. Thanks both to the attorneys. Commissioner McGowan.
Thank you, Mr. Chair. And so in reading KPK's I'm not sure, sorry what the document name is, but there's a reference to Utah versus Pacificor and this, what was highlighted. And I'm wondering if both of you could speak to this. For a continuing violation to exist, there must be some affirmative conduct within the limitations period, and not merely the abatable but unabated inertial consequences of some pre-limitations action, and how you understand that, what that means.
I can speak to that briefly first, if I may.
Go ahead, Mr. Dickus.
I believe the court is referring to passive migration. This was an issue in the Thorough Products case that the Colorado Supreme Court addressed as well. That's the reference to inertial, occurrences, if you will. Thorough had to do with prior disposal of waste, hazardous waste, and its migration, and does its migration alone in that criminal case constitute a continuing violation of the requirement to not dispose of hazardous waste without a permit, Commissioner McGowan. And in that criminal context, they said, no, they were not going to find that it was. So the affirmative act is the act of the defendant or the respondent, in this case, perhaps using hypotheticals, the inertial movement of material without any more affirmative action by the defendant. That's what the court in Utah v. Pacific Corp is talking about, I believe. But I welcome Ms. Stafford's perspective.
Ms. Stafford, do you want to lend your perspective?
Thank you, Chair Robbins. I would just like to point out that this particular case is in a criminal and not a regulatory perspective. And to the quote that you're speaking of, there must be some affirmative conduct within the limitations period, and not merely the abatable but unabated inertial consequences of some action. I believe that's speaking to the ability to correct. And what staff would submit here is that the failure to correct a site inspection violation, which would include correcting a form submittal or a notification violation in this instance, starting the dialogue with the agency, that constitutes a continuing violation here. That is something that we are giving an operator an opportunity to correct by providing the information, even though they might have gone past the specific due date. We need the information. That is the point.
A brief rejoinder, if I may, Mr. Chairman.
Keep it brief.
Very brief. Just a clarification, really. The Utah case about which Commissioner McGowan was asking is a civil dredge and fill case, Clean Water Act 404. And so once the fill is in the wetland or the stream and is sitting there, that's the inertial kind of release that the court was concerned with. It's not a criminal case. So I just wanted to clarify that.
And my apologies, I misspoke there because I was thinking of one of the other cases that they cited. So.
Great. Thank you both. Any final questions? Commissioner Gonzalez.
Mr. Chair, I've got a question on maybe specifics to the allegation around NESU number 1 and some of the timing that occurred there. And it applies to this discussion of statute of limitations. Now, I'm curious, is that appropriate for me to bring up here in this forum, or is that more appropriate in response to closing arguments?
I would suggest that may be more appropriate in closing arguments when we peek into the facts. But
fair enough.
I was struggling with some of those dates that were thrown out there too. So if both sides could be ready to talk about those dates, that would be appreciated.
I think we have so informed our attorneys that are appearing before us. Okay, seeing no final questions, thank you both for your argument on the statute of limitations. I suggest we take a 10-minute break and then come back for closing arguments and then questions for that. I just suggested 10 because I don't know that we need 15. We're not going that long, but let's come back at 10:40.
Thank you.
All right, commissioners, I should have suggested a 15-minute break after all. It seems like that's what was necessary. Good to see everybody back with us. We have counsel of record for both parties. We now will move into closing statements. I would anticipate that we will hear closing statement from KPK for the allocated 15 minutes up to, you don't need to use all 15, as well as then staff, 15 minutes up to, and then we would have an opportunity if there are any questions from commissioners for either side following both closings.
Commissioner
Chairman?
Robbins?
Y-
Chair
Yeah, go
Robbins?
ahead, Ms. Stafford, and then Mr. Jacobs.
I was just hoping to get some clarification on the commissioner questions following the closing arguments here. Would this be a situation where you want to have us potentially recall some of our witnesses for a factual question? Or I guess I'm just trying to get a sense of what we should be prepared for here.
I think it could be either or. It could be questions of edification from you or to you relative to your closing, relative to your case. I think it also could be questions for a particular witness if they feel that there are areas that need further inquiry. So I guess I would suggest be nimble and be ready for either.
Understood. Thank you.
Mr. Jacobs?
Yes, clarification on order of closing. Staff has the burden. They're essentially the plaintiff in this action. Typically, the plaintiff would close first and defendant or respondent would follow, and I would prefer that order.
The order was what my attorney general told me to order it, and he's not in the room. So, Ms. Stafford, do you have thoughts on order of closing?
I don't know that we have a particular preference, but I would note that it's been ordered like this since we received the initial final pre-hearing order. So I think this is sort of an untimely argument.
Go ahead. We'll let KPK go first.
Very good. Mr. Chairman, commissioners.
Excuse me, it's Mr. Mueller interjecting. Did your AAG just return, Chairman?
He did, and he's in agreement with me. Thank you, Mr. Mueller.
Can we reset the clock, please?
It hasn't started.
Okay, thank you.
Sorry, Mr. Jacobs.
Oh, not at all.
As a point of order, I've been practicing litigation for 35 years. The order is typically that the complaining party goes first, but we defer to the commission.
Proceed when ready.
Yes.
Mr. Chairman, commissioners, this portion of the OFB hearing concerns alleged violations and proposed penalties asserted in 5 notices of alleged violation. Over the last 3 days, you've heard lengthy testimony and reviewed numerous exhibits concerning those allegations and KP Kaufman Company's responses and defenses. We appreciate your attention to the testimony and evidence presented. And now KP Kaufman asks you to carefully consider everything before you. As you know, staff bears the burden of establishing violations by a preponderance of the evidence. It has not met that burden in many instances, and even where you find it that it has, that you may find, staff has mischaracterized the consequence. Regarding missed form filing deadlines, for example, staff has conflated impacts to its work functions with actual impacts to the environment, public health, safety, welfare, and wildlife resources. When asked, staff has no data to establish actual real impacts for missed deadlines. Staff's mantra of unreliable, incapable, and impactful is catchy, to be sure, but the narrative is a distraction from the actual specific findings you must make, and staff has not established many of their rule-specific allegations by a preponderance in these proceedings. Your specific findings must relate to the language of each rule staff alleges to have been violated in each NOAV, not staff's broader narrative. Indeed, the first 2 adjectives in staff's mantra are entirely inappropriate to your task now at hand, as there is no place for considering reliability or capability in any of the individual violations. You must now consider one at a time. By attempting to paint a picture of KPK's alleged noncompliance in broad strokes, staff attempts to cloud and bias your careful consideration of each alleged individual violation, the disputed facts at the core of the allegations, and your balance of the evidence. Let me be clear. While we have vigorously defended our client and presented the other side of the story, The KP Kaufman Company does not intend to shirk its responsibilities as an operator, and it owns that it has made some mistakes. Those mistakes notwithstanding, KP Kaufman, just like any other operator, must be treated and judged fairly regarding the actual requirements of commission rules. And as you know from testimony over the last 3 days, with regard to staff's enforcement of certain of the NOABs, KPK adopted new policies and practices when it learned staff's position and adjusted its practice with staff's position in mind. If the point of these proceedings is to return KPK to compliance, as we believe it should be, rest assured the Commission has captured its full attention. Turning to the specific NOABs and the weight of evidence and testimony presented, it is clear that staff has not met its burden in regard to many key allegations, including but not limited to the following. At the Upper 43 location, the evidence is clear that KPK had responded promptly to the notice of an active gas leak at the location where work had begun to not only repair the leak in a carbon steel line, but to upgrade a significant length of that line, including the location of the hole which allowed the gas release. KPK had isolated and depressurized the consolidation line prior to engaging in excavation to repair and upgrade the line on September 23rd, 2020, after staff inspected the location and discovered an audible leak of gas. Staff's characterization of the audible leak as massive is not supported by any quantitative data or reference to any standard other than it being a grade 1 gas leak, which KPK does not dispute. KPK took care to monitor the line for possible repressurization when Max Knopf viewed the leak with an IR camera pending repair, again the next day following the response to repressurization, and found no evidence of vapors emanating from the failed section of flow line. And when vapors were again detected by staff a day or two later, KPK promptly responded again, depressurized the line, and installed temporary ball valves and bull plugs to guard against repressurization, the cause of which was later concluded to be the result of debris fouling the isolation valve upstream. Debris fouling the valve was unforeseeable and not the result of any failure to conduct commission-required maintenance, as KPK witnesses confirmed their performance of annual functionality testing on all isolation valves on its flow lines. KPK did not continue to operate the affected segment as alleged under Rule 1102I2. Isolation valves were in a closed position at all times during the efforts to repair the line and the unanticipated gradual repressurization due to the fouled valve. Upstream isolation valve functionality was then evaluated through pressure testing prior to returning the previously fouled valve to service. And to the extent a violation is found, the violations should be reclassified from major to moderate due to the lack of evidence from staff on actual significant impacts as opposed to threatened impacts, more consistent with the import of staff's label of near miss, an undefined term that staff never defined even in this hearing and appears nowhere in commission regulations. At the NESU 1 location, a preponderance of the evidence establishes that photographic evidence provided by staff shows berms were present around a screened soil pile at the location, and allegations of a partial lack of berms in certain areas during the days when active excavation was proceeding do not account for the need to let heavy equipment get close to the screened soil pile. Undisputed testimony indicates that KPK encountered significant historic contamination, which was specifically acknowledged by staff in its approval of the initial Form 27 submitted by KPK. Consistent with staff's expectation, KPK removed this contamination despite the fact that it is not the responsible party under Rule 100 with respect to that historic contamination. KPK acknowledges that it was late in submitting its Form 27. It misjudged the challenges of removing the significant historic contamination, which greatly complicated and delayed the ability of KPK to characterize the site conditions. And staff's efforts to tie a line between the missed deadlines and actual or threatened impacts are exaggerated at best. And KPK subsequently implemented a tracking system to facilitate better calendaring of those deadlines. At the NESU consolidated location, the preponderance of the evidence establishes that the release was estimated at less than a barrel and the field was dry and not being irrigated when the surface tenant first notified KPK of surface staining. Staff's assertions that a release of less than a barrel in a dry cornfield was not being irrigated nonetheless threatened impacts to waters of the state was not even capable of articulation by staff as an objective standard that could ever be met with confidence by an operator determining reportability. KPK witnesses confirmed that the entire NESU battery and flow lines had been shut in with isolation valves to enable work on the NESU 1 flow line. So further isolation of the line was neither possible nor necessary to stop the leak. The staff indicated the surface tenant's subsequent complaint to the commission about a lack of progress in addressing the release was by his own account 9 weeks prior to his January 14, 2020 complaint. KPK witnessed testimony that the leak was repaired in time for the tenant farmer to plant his crop and be fully compensated for his losses was uncontroverted by staff. And this event was ultimately not a reportable spill and thus should never have had a specific condition of approval date by which to submit a Form 27. Turning to the soil spread field location, a preponderance of the evidence establishes that KPK transported screened soil to the spread field location that it believed was below TPH levels of concern, specifically to accommodate the landowner at NESU 1, and purchased clean fill and topsoil for backfilling of a very large excavation to accommodate those concerns and redress his damages. You heard the testimony of KPK personnel that they did not intend to treat or dispose the screened soil at the spread field location, and you heard them admit that they had erred. And you heard that not only did KPK not realize an economic benefit from moving the screened soil, rather it incurred significant additional expense. And while this was an error on KPK's part, staff has exaggerated the actual consequence and impacts. The soil residing at this location was collected and disposed of. After the soil was removed, testing revealed no significant lingering impacts to the native soil or groundwater. And recall finally that this field belongs to the Coffmans. Challenges of COVID-19 also delayed the completion of removal of soil taken to the spread field, but certainly not the commencement of that action of removing that soil, which we believe is the operative date for stopping the clock. And at the Jilson 5 location, a preponderance of the evidence establishes that upon notification of a potential gas leak at one of 3 operators' wells, KPK responded promptly, identified that the Jilson 5 well had developed a gas leak, and immediately shut in the well to stop the leak. Was the leak reportable? The fact that Mr. Canfield would like operators to report everything notwithstanding, this event must be judged by the language of the regulation. A release is reportable only if it poses an actual threat. Based on the observation and descriptions of the first KPK representatives, this was a minor leak from a low pressure, low flow line in an open field. Staff deemed the leak a minor violation, and there is no evidence that it constituted a threat to the adjacent public byway, nor did it constitute a distraction to motorists. For all the references to secondary containment, there is no mention of this in the regulation, and it is not physically possible for gaseous releases. And if they were secondarily contained, they would not be a leak at all. Staff's second alleged violation at Jilson 5 is based on KPK's alleged lack of coordination with the landowner. But you heard Avi Mailer testify about his frequent emails and calls with the Thomas family, who were frustrated not by lack of communication, excuse me, but by the speed of repair, which is not an element of the alleged violation. Finally, in addition to the mitigating and other penalty adjustment factors you heard this week, it is in the Commission's own interest to consider KPK's ability to pay the penalties being requested by staff for the 5 NOAVs at issue in this part of our hearing. KPK's expert witness and KPK witness Richard Stoltz, the company's CFO, testified to KPK's limited ability to pay the huge fines staff proposes due to commodity price volatility, the effects of the global pandemic, and the obligation to meet consent decree obligations to the United States and the state of Colorado under a Clean Air Act consent decree, among other factors. Mr. Stoltz, who also testified how, although KPK reduced expenditures during the global pandemic, environmental compliance functions increased as a percentage of total expenditures during that difficult time. Ability to pay is a consideration stated in the Commission's penalty policy and contemplates the effect a penalty might have on an operator's ongoing operations in Colorado. It doesn't matter if ability to pay is raised in settlement or in litigation. The underlying policies behind this concept apply equally in both contexts. That is, the Commission is discouraged from imposing penalties that might jeopardize an operator's ability to conduct necessary environmental remediation or delay the operator's ability to perform necessary corrective actions or remediation. This ability to pay factor is also designed to keep an operator from orphaning its assets and leaving the state with unfunded liability for remediation. For these reasons, KPK urges this Commission to seriously consider this important factor to achieve the best environmental outcome, one that does not include putting KPK out of business in Colorado, but allowing it to return to compliance with an adjusted deterrence amount. We urge you to consider as you deliberate that the goal of enforcement proceedings is to correct behavior, not to extract vengeance. Staff's mantra of unreliable, incapable, and impactful, its constant use of pejorative phrases like dumping, might excite passions at a campaign rally, but this Commission needs to navigate the new regulatory environment with a measured, balanced, and unbiased hand that will inspire confidence in both the public and the regulated community. Thank you.
Thank you, Mr. Jacobs, for that closing. We now will allow staff the opportunity for closing. Ms. Stafford, you have 15 minutes.
Thank you. Thank you, Chair Robbins. Unreliable, incapable, and impactful. Commissioners, on Wednesday, I stood before you, albeit virtually, and told you about KPK, an oil and gas operator who consistently fails to comply with the Commission's rules. And I stated that KPK is unreliable because they cannot meet deadlines or approved timelines. I stated that KPK is incapable because they cannot fulfill their obligations to the Cogcc and the state of Colorado. And I said KPK is impactful because they cannot timely and adequately clean up their messes. And these descriptions have proven to be true through the testimony, evidence, and the written record in this matter. I also told you, Commissioners, that these 5 NOAVs are pretty straightforward. In fact, many of the facts necessary to prove the violations are contained in the parties' joint stipulated facts. And through the evidence and testimony you heard over the past 2.5 days, staff has met its burden to prove by a preponderance of the evidence, or more likely than not, that KPK committed each violation of Commission rules as alleged here. Now, KPK has tried to confuse you and make these violations more complicated than they actually are. In many cases, they introduced information that was simply irrelevant to the rule and violation at issue. So let's talk about a specific example of that in the soil spread field matter. Recall the language of prior Rule 908, and I'll read it right now. Quote, before any person shall commence construction of a centralized E&P waste management facility, such person shall file with the director an application on Form 28 and pay a filing and service fee established by the Commission, see Appendix 3, and obtain the director's approval. And again, just to restate, we are referencing the rules that were in effect prior to January 15th of this year. So here, in order to prove the violation, that is more likely than not that the violation occurred, staff must have shown 1, that KPK commenced construction on an E&P waste facility, and 2, did not apply for or receive director approval. So first, let's look to the testimony of KPK's own witnesses in the NESU number 1 matter. The soil they assumed to be clean, but that we now know was actually E&P waste, was transported to the spread field location and dumped in the field. The parties' joint stipulated facts on the bottom of page 3 of that document also discuss this point. So dumping the E&P waste in the field, by doing that, KPK commenced construction of an E&P waste facility. Now let's turn to the parties' joint stipulated facts again, pages 3 and 5. For the second part of this, application and approval. And I'm looking at page 17, number 25. At all relevant times, KPK did not submit or possess a Form 28 centralized E&P waste management facility permit to utilize the spread field location as such a facility. The testimony, evidence, and written record support a finding of violation here. Instead of acknowledging their violations, KPK improperly attempts to read an element of intent into the rule. Now, you might have heard that during their presentation, they suggested they could only have violated this rule if they intended to build a centralized E&P waste management facility. But there is no element of intent in prior Rule 908B. It's just not there. Once they dumped those E&P wastes that by definition are associated with oil and gas extraction at the spread field facility, that, quote, facility was constructed. As a result, the facility was there without proper approval and without proper permitting. And as staff showed you through the evidence and through the testimony and through the joint stipulations, KPK violated Rule 908B. I could go through each rule, element by element, and again describe how staff carried its burden to prove that more likely than not, KPK violated each rule as alleged. And if you'll recall, for the most part, staff did much of this at the conclusion of the presentation for each NOAV, or even earlier in our presentation of evidence. But since we are a little time limited here, I am confident, Commissioners, that we have set forth testimony, evidence, and a written record, and specifically the joint stipulations of fact, that support finding a violation of each rule as alleged in each NOAV we brought before you in this phase. Now, in addition to seeking to confuse you, KPK also tried to introduce uncertainty here when talking about spill reporting requirements and impacts to waters of the state or public roads, also known as byways. And here they implied the rules are not clear on when there's a threat that could impact waters of the state or a public road. They implied that there was some kind of lack of clear standard. But as staff's inspectors told you in their own words, they do not make this decision lightly. Staff carefully considers each situation on a case-by-case basis and makes a thoughtful determination about the proximity of a certain spill to each of these sensitive receptors. And it's not just that the spill occurred on irrigated cropland, as in the NESU consolidated matter. It's also that, as KPK's own witness told you, there are features like an irrigation ditch a few hundred feet away in close proximity to the area of concern. That irrigation ditch is certainly waters of the state, and we hope you weren't too sidetracked by KPK's unnecessary focus on raindrops. What is truly evident in the allegations in the NOAVs and the testimony, evidence, and written record that you have heard and read is that KPK doesn't know what they're doing when it comes to properly reporting a spill according to Cogcc rules. They are simply incapable of properly reporting spills according to the prescribed rules. In contrast to this confusion and uncertainty, staff has presented you with a roadmap to find, by a preponderance of the evidence, the violations as alleged in each of the 5 NOAVs. Almost all of the information you need here is in the parties' joint stipulated facts. I'll remind you that these are facts KPK has already agreed were undisputed prior to this hearing even starting. And they get you most, if not all of the way, to finding them in violations of the rules here. And staff's evidence and testimony get you the rest of the way. For example, in the near miss matter, staff inspectors told you they heard audible hissing from a leak in the line when they arrived on site, that gas was releasing to the atmosphere, and that they were concerned for public safety and the environment. Staff also told you about stockpiled waste without any BMPs or any clear evidence regarding how long waste had been there or what KPK's plan was to remove it. In NESU number 1, staff told you how the lack of information on spill cleanup affected their ability to manage the remediation, depriving them of crucial information to ensure environmental protections, and how the lack of best management practices caused hydrocarbon impacted soils to be tracked around the site. Staff told you in NESU Consolidated a similar story, a lack of information due to KPK's blown reporting deadlines, leading to significant concerns of ongoing environmental impacts at the location. In the soil spread field matter, staff again filled in these gaps. Hundreds of dump truck loads of oily exploration and production waste dumped in a field within 100 yards of a freshwater pond and less than 400 feet from mapped wetlands. That last fact is contained in the parties' joint stipulated facts. And finally, in Gilson number 5, staff told you they didn't even know about the spill until 2 months after the fact. No notice from KPK, no heads up from KPK, no questions from KPK to staff to begin a dialogue to seek direction. Just KPK substituting its own unreliable and poor judgment for that of the agency in deciding what to report and when to report it. And when discussing communications with the landowner, staff showed you the effort it took for the landowners to get information on cleanup efforts. Good faith communication isn't merely responding to emails asking for progress updates on a project that clearly hasn't progressed in weeks. When we're talking about a project to begin excavation, remediation, it means an operator telling the landowner when they will actually show up, and it includes additional follow-up and further communication. Commissioners, you heard KPK attempt to minimize the actual impacts from these violations for the past 2.5 days. And while we can have an honest disagreement about the exact nature of impacts, what cannot be denied is that there were threats to public health, safety, welfare, the environment, and wildlife resources from each of these violations. And that word, threat, shows up in many of these rules and the impact classification. KPK would have you ignore that word, but staff is unwilling to scratch that word from these rules without a rulemaking. Commissioners, as staff has shown you through testimony, firsthand observations, documented evidence, and importantly, the parties' joint stipulated facts, this is a case about an oil and gas operator that consistently fails to comply with the Commission's rules. And instead of following the rules, KPK sets forth excuse after excuse. They told you it's common for landowners to report spills to KPK and to file complaints with the Cogcc. It's really not. In the end, KPK continues to minimize the effect of their violations, and they continue to deflect responsibility. KPK is unreliable, KPK is incapable, and KPK is impactful. Commissioners, staff is not focused on extracting the maximum penalty from KPK. Instead, we want you to order KPK to live up to its obligations to the people of Colorado because they have clearly stopped listening to staff. On behalf of staff, I thank you for your time and your thoughtful questions during this phase of the hearing. And on behalf of staff, I ask that you find KPK in violation of each of the Commission rules contained in the 5 NOAVs before you here and impose staff's requested relief. Thank you.
Thank you, Ms. Stafford, for the closing statement. At this time, I believe that we have an opportunity for any questions from commissioners to the parties at this point. And I would suggest that perhaps we organize questions in the order in which we undertook this matter. So we would start with the UPER matter. Whether I'm not finding it. Is that okay with commissioners? If we have questions, we can go in that order. So any questions on that first matter For some reason, I don't seem to have it. I'm missing page 3. Yeah, the UPRR 43 Pan Am G consolidation number 2. Any questions on that matter? Commissioner Messner?
Thank you, Mr. Chair. So a few different questions, and the first one will go to COGCC staff. And Ms. Stafford, I'm not sure that you can answer this, and so if we need to wait and I can ask this later, then that's fine. As I was going through my notes, I was a little confused whether or not COGCC staff visually observed any KPK personnel working on the flow line repair while the line was pressurized. So KPK staff came to the site while COGCC staff was there, but it wasn't clear to me as I was reading the exhibits, or at least my notes in the testimony, that there was actually a staff visually observing KPK personnel working on the site.
Thanks, Commissioner Messner. I'm going to throw that to Ms. Rosenberg since she was the attorney who presented that matter.
Thank you. And I'm sort of struggling with my words here because, you know, I don't want to testify and get more evidence into the record because that, you know, the witnesses did. But if I'm understanding you correctly, staff's observations were that a KPK crew arrived to the south excavation, and staff believes that crew was undergoing repair work. And we did provide evidence through exhibits that talked about even if KPK were simply dropping off materials, the safety requirements for those particular materials said that in a gaseous environment such as the one that it was at, that even that was unsafe. That was the evidence that we provided, and KPK disagrees with that.
So similar question to you, Mr. Jacobs. Did any KPK personnel begin working on flow line repairs prior to being required by COGCC staff to stop work due to safety issues?
No, Commissioner Messner, excuse me. I think that the testimony of our KPK witnesses is clear that the crew that Ms. Rosenberg is referring to was simply dropping off pipe for the eventual upgrade of the line from the south excavation under the road to and including the location of the leak, the hole in the carbon steel line. And they were not engaged in work on the line. They were staging material for use in that future work.
Commissioner Messner, if I could, AAG Davenport would like to weigh in on this line of questioning, I think.
Thank you, Mr. Chair. I just would like to remind the commissioners that obviously Ms. Rosenberg began her answer to your question, Commissioner Messner, by a concern. I would phrase it as that she doesn't testify in place of how a witness testified. I would remind the commissioners that the council's statements here to your questions are not evidence in the sense that they're not sworn witness testimony and they're not exhibits that have been admitted into the record. So while they may be helpful to you in summaries of what the evidence was, the actual evidence is what the witnesses said and the documents in the record. So if you have concerns about what was said or need some help in that regard, the best place to find that is by reviewing what we've already heard going back to the YouTube or whatever it is.
Okay. Thank you, AAG Davenport. This is all our first rodeo, as you're fully aware. So with that in mind, we'll continue. Commissioner Messner, you still have the floor if you have additional questions.
I do have a couple. And so I've read the stipulated facts, I've read the exhibits on this particular one, this particular NOAB. It appears to me that there was no exhibit that provided a maintenance log or documentation of performed tests or repairs of isolation valves. I wanted to confirm that that was the case.
I can speak to that. I believe it's addressed to me. Is that correct?
Sure.
Go ahead, Mr. Jacobs.
I'm referring to the testimony of KPK witness Manuel Silva. He indicated that annual functionality tests were performed. And I believe that he also testified, although I would recommend you double check this, that those tests, while required, are not required to be logged or recorded in any specific report under commission rules. Now, I'm also aware of your request of yesterday for some maintenance information, and we've been trying to pull that together, and maybe after a break later this morning, we can discuss what we've been able to pull together in such a short time, long after the close of discovery in this proceeding.
And if I may, I would like to direct the commission to page 3 of Exhibit 716, wherein KPK says in writing that we perform annual functionality tests and documentation of tests and repairs. We do not keep that. And in addition, KPK had an obligation to set forth their best defense and provide evidence of these repairs prior to this hearing and chose not to do so.
Object to the characterization of repairs. We're talking about functionality testing.
I misspoke. I meant maintenance logs, annual test logs. I misspoke when I said that.
Okay. Last question, at least initially here, and this is to staff. I wonder if there could be an explanation as to why 324 AA is unique and distinct to the other alleged violations.
Are you referring to the 907A allegation as well?
So we've got a number of violations here, and if you give me a second, I can pull up those. So we've got alleged violations of 324AA, 906A, 907A, 1102I2, 1102J1, and then 1103A, 605D. I'm trying to get a little better clarification on staff's interpretation of Rule 324AA and how it's unique and distinct to the alleged violations of the other rules in this table.
In a nutshell, and staff's position is that 324A relates to the actual impacts that occurred at the site versus other rules that had to do with the steps leading up to those impacts occurring. So in that regard, it's a distinct rule violation.
Okay, thank you.
Commissioner Gonzalez, I think I saw your hand.
Thanks, Chair. And I was looking for some specific, but I think I can move on without that. So in regard to the UBER 43, the allegation of failure to maintain the isolation valve under Rule 1103A. I think we heard testimony from KPK that the valve itself was operating according to manufacturer specifications. It was operating correctly, and that in fact the prevention of it operating correctly was outside the actual function of the isolation valve, that being the debris in the line. So what I'm trying to understand is how is it that if a line is maintained in accordance with manufacturer specification, but yet some other foreign object introduced into that function or into that piece of equipment causes it to not work or cause it not to have the same result, should I say, as if it was manufactured or as if it was operated within those specifications. How is that a violation of this rule?
Well, to answer your question, I also want to point out my understanding of KPK's witness testimony was that the valve itself has actually never been checked. There is an assumption that there was debris, and had the valve been properly, the line been properly maintained, that wouldn't have occurred. And in that instance, it was considered then to be a failed valve. Again, that was just based off the witness testimony as I understood it.
I respond.
Go ahead, Mr. Jacobs.
I don't believe the witness or the KPK witness testimony is as characterized, with all due respect, by Ms. Rosenberg. That valve, after we concluded debris fouled it, was allowed to clear when the line was repaired. It was pressure tested before returning to service. It passed the pressure testing. That is functionality. It held pressure when closed. The instance of debris, which was concluded as the root cause, had been rectified. And this could be the same type of situation for a perfectly new valve. And the notion that maintenance of the line, as referred to by Ms. Rosenberg a moment ago, was even at issue is not part of the violation. It's functionality of the valve.
And if I may,
go ahead, Ms. Rosenberg.
well, you know, and I want to express discomfort with sort of this way that this is proceeding, because you are all the deciders of fact and get to determine what the evidence was and what the testimony was. And at this point, it's just me sort of giving my impression of what I observed yesterday and trying to recapture what staff had presented at the hearing yesterday. And I just want to make that statement here.
Sure, and I understand that, and I tend to agree with your characterization of the testimony that perhaps it was an assumption that there was debris in the valve. However, I'm asking, even if that turned out to be the case, and we did put weight to that testimony about there having been debris in the valve, does the presence of debris in the valve mean that the valve was not properly maintained according to manufacturer specifications, which is kind of the part of Rule 1103 that's cited in the allegations. And that's what I'm trying to get at here.
And yes, that is staff's opinion and what we thought we presented yesterday with the evidence.
Sure, thank you.
Any additional questions on the first matter? Okay, seeing none, then we will turn to questions on the NESU number 1. Are there any questions there by commissioners? Commissioner Gonzalez?
I just wanted to make sure I got my hand up before we moved on. I'm trying to find my notes here on it. I have a question. This is what I was thinking about when we were listening to the statute of limitations presentations and arguments. And, you know, reading back through the allegations and the date of the NOAV for specifically Rule 907A as it applies to the NESU number 1, you know, the date of the NOAV and the date of the allegation, or the date of violation, should I say, was November 13th, 2019. And the way I understood the testimony, or I don't know if it's appropriate for me to kind of walk through that, but I'll skip over a high level. But I will say that it seems to me as if there was 2 distinct violations in there, or 2 distinct kind of allegation of violations, but 1 violation date. And I'm curious as to what that means to the application of a statute of limitations argument when you have a violation date that is outside the statute of allegations, that violation through testimony, or at least there was some evidence brought up that that violation was corrected, and then subsequently that same rule was applied to an additional violation, that being the maintenance or the integrity of the berms later on. You know, when that comes up for that secondary violation, why is it all kind of lumped together into that one violation? And why should we put weight on the violation of November 13th, 2019, that berms needed to be installed, and then on January 20th, the allegation of violation that berms were not properly maintained? I'm trying to understand why that NOAV was, why that violation was tied to that November 13th, 2019 date and not to the January 20th, 2020 date. I think I danced around that a little too much, trying not to get into all the facts I'm thinking about, but perhaps staff's counsel can answer that for me.
Or, excuse me. And if I could just, so I think what I've understood you to ask might be two different questions. So I'm sorry, I'm just trying to pull some of this information up here. So you were asking about Rule 907A or Rule 901C, because
Rule 907A with the failure to properly store the BMP waste to prevent environmental impacts, and specifically as to the allegation that BMPs were not installed. Those BMPs, my understanding being, are the berms surrounding that stockpile.
Okay, so I'll see if I can clarify this a bit. So staff's allegation stems from the inspection report. So on the date that that particular violation was observed. So then that KPK was given an opportunity to correct that violation, meaning they were given a corrective action due date, and they did not comply with that corrective action due date. So the violation continued here, and our point is here, and what we've have in the record at this point. Again, we believe, and I will say again, I don't want to be understood as testifying here. This is my opinion of how this was all calculated. So I just want to be very clear there. This end date of 5/21/2020 was put into place because that is the day that soil pile was removed, mooting the need for any berms to be placed there anymore. Does that make sense?
That makes sense, and I understand
Okay.
that. The testimony that I heard, the timeline that I heard, was November 13th, 2019, staff inspected, told KPK to install the BMPs, being the berms. They went back on January 20th and said, hey, these berms that seem to have been installed subsequent to that November 13th, 2019 BMP were later, at January 20th, their integrity had been, I guess, affected because there had been, they had been washed out, or the berms were not fully around at all points of that stockpile. And so it seems to me that 2013-2019 BMP was corrected and that was installed. But then on January 20th, when staff went to go visit, and I think these are all stipulated facts, that they observed berms in place, but that those berms needed to be repaired. And then they gave the deadline of January 22nd for those berms to be repaired. It is my understanding that it is the repair of those BMPs on January 22nd that staff is alleging as part of that same violation of 907A, as was the original BMP requirement from November 13th, 2019. My understanding is if that November 13th, 2019 BMP was corrected, perhaps with later repairs needed, but if it was corrected, then why was the NOAV violation date tied to that date and not to the subsequent January 20th, 2020 date, 22nd?
Thank you, Commissioner Gonzalez. And I guess I'm looking at the stipulated facts myself right now, and I'm not seeing where staff was ever able to confirm that there was a corrective action met following the November 13th, 2019 date. So I guess what I'm saying is the violation continued because it was not, the berms were not there, or
So,
there weren't full berms, I guess I should say.
So I agree that there's nothing in the stipulated facts, and I don't even recall in testimony, if I heard it, whether or not there was testimony as to when those berms were installed. But intuitive to me, based on the stipulated facts and the testimony, there were some berms installed, and then they were asked to be repaired. And it was the repair of those berms that to me makes it sound like, even though there's a gap in the stipulated facts, that's something that we can consider, at least in the testimony. And so that's what I'm trying to get. I'm just trying to understand, hey, we're thinking about statute of limitations as a potential defense here. And does that apply to the January 20th violation? Does it apply to the January 22nd violation? Or are we going back to November 13th, 2019 violation as stated in the NOAV? And that seems to me as if that was done, perhaps with subsequent corrective action afterwards. Does that make sense?
Commissioner Gonzalez, I would like to interject here. It seems to me as though we might be getting into commissioners beginning to deliberate while taking input from the party lawyers. And I'm starting to have concerns, and I just wanted to raise that. Thank you.
Okay. Well, that's for the chair to rule on, I suppose. But this is what I'm trying to figure out.
Mr. Chair, if we have concerns as well with that exchange.
Let me have Ms. Stafford weigh in, and then we'll give you a chance, Mr. Jacobs.
Thank you. Me or Mr. Mueller. Thank you.
Thank you, Commissioner Gonzalez, for the question. So it's staff's position that both missing berms and inadequate berms both violate this particular rule. And that's why the violation began at the earlier date.
Mr. Mueller?
I'm not overly concerned about the deliberation piece of this. I think Mr. Gonzalez is asking an interesting question. And I think you all will have to weigh the evidence that you heard. I recall that it was Inspector Canfield who was out numerous times and reported in all visits that he did not see berms. And as it's alleged in the NOAV itself, it does appear that this is, the same ongoing violation, not having berms commencing on November 13. It was discovered they weren't there, and thereafter each return visit indicated they still weren't there or they weren't properly there. But it goes to your good question, Commissioner, about why do they measure it from the earlier date? I can't answer that, but it certainly suggests they believe that that's when the violation occurred and it continued thereafter.
And if I might correct my esteemed colleague, I believe it was Mr. Gintautis who was at that location, not Mr. Canfield. But otherwise, don't disagree. And I would just raise the concern that in Commissioner Gonzalez's exchange regarding stipulated facts, the mention of the very important word alleged, which appears frequently in those stipulations, was not mentioned. So there are stipulations that talk about alleged violations and the allegation of lack of berms and inadequate berms, which are still disputed and you must weigh the evidence on. Thank you.
Mr. Chair, point of order.
Commissioner Messner.
So it's my understanding that there was an opportunity here to ask questions of staff with the record, questions of the parties with the record open in order to better understand what was presented. If there's going to be continual issues and objections to having a discussion and asking questions about this in order to be able to better clarify as we begin our deliberations, then I would actually support closing the record here sooner than later so that we can begin deliberations on the record.
Well, and I think at this point, what we have afforded ourselves is an opportunity to have discussion with counsel of record to make any clarifications regarding their legal theories regarding the case. I think if commissioners have questions around the facts, the first thing that we should do is go back and review the record, and we've got the YouTube video to do that. If commissioners believe that there are places in which additional facts need to be developed, then that is yet another opportunity to call back a witness at this point in time. So I think those are, in my mind, it's sort of two discrete things that we ought to be trying to accomplish this morning. And I would look to AG Davenport if you think I've got that wrong or otherwise. Again, we've not done this before, so we're sort of creating a ship as we're floating it at the same time. But those are my perspectives on what we ought to be doing. In terms of closing the record, I don't want to close the record until we are close to being done with deliberations. And so that's Monday. And the reason for that is if we start to deliberate and we realize there's a factual void that needs to be filled, I want to be able to bring a witness back to fill that void. So that at least is my perspective. AG Davenport, do you want to correct me or add to this in terms of what it is we're attempting to accomplish right now at this point?
Thank you, Mr. Chair. I don't have anything to correct. At this point, I would like to, with the chair and the commission's indulgence, address deliberations, which Ms. Rosenberg raised. I do think it's appropriate to begin deliberations after the commission has all of its questions answered. I think it's also appropriate if a commissioner needs to give some context for their question as to where that comes from, and that context may include what you're thinking right now. That's appropriate as well.
And Mr. Chair, now I understand this is a sticky and inartful question. It was like that in my brain, and that's how it came out. And so I tried my best to stay away. I'm comfortable with the testimony I've heard so far, and I think I'm limiting what my thoughts are to the testimony that's been presented, and not asking for any clarification on testimony or facts. I've heard from both attorneys on this. I don't know that I've heard a great answer in either way, and I'll take what I've got and go from there. So I appreciate the point of order from Commissioner Messner and the clarification. I kind of was worried about that as we were stepping into it, but I can cease my line of questioning in that regard. I think I'm done.
Okay, thank you, Commissioner Gonzalez. With that, are there any additional questions with regard to NSU number 1? Go ahead. AG Davenport.
Mr. Chair, thank you. It's not common for me to ask questions in an open hearing, but given that my job is to provide the commission with counsel, I do have a question to clarify position in KPK, that KPK is taking in regard to the NSU number 1 NOAV, and it has to do with responsible party doctrine. My question, and it's a clarification of KPK's position in regard to responsible party, and that is, I am not sure if KPK is arguing that it should not be liable at all for the violations alleged by staff as to NSU number 1 because it was not a responsible party, or if it is arguing that the penalty should be reduced from the violations because KPK was not a responsible party, or both. And whichever KPK's counsel would like to answer that, that would be appreciated.
I'll go first and let Mr. Jacobs correct me if I make any mistakes. We deny that there was a release, that we own some part of that, and we cleaned that up. But we did clean up a great deal more, and therefore we think it goes in the direction of reducing the penalty.
Mr. Jacobs, do you want to correct your counsel?
Only that we assert both with respect to any liability associated with the historic contamination, and that we also wish for penalty adjustment due to having to clean up another party's spill. As you heard, at the time, KPK had owned the line less than 2 years, and our expert witness, Mr. Peterson, testified that that was historic contamination. It took a very long time to move through that clay subsurface material, and that's all clear in the testimony of record. So our position is that we're not responsible for the violation as it relates to that historic material, the alleged violations. And as Kirk stated, we'd like an adjustment to reflect that. in any penalty that might be assessed should you find a violation.
Any follow-up, AG Davenport?
Thank you, Mr. Chair. I do have one follow-up, and I appreciate the response, and that clarifies things for me. Thank you, counsel. My follow-up is, do you have a position on how much a penalty should be reduced as a result of your position on responsible party?
Mr. Mueller, I think I'll take that. There was testimony that approximately 3 times the volume of new contaminated material was the result of historic contamination, and also that we incurred substantial remediation costs that exceed the proposed penalty. And then there was reference to the penalty policy and how that comparison of remediation costs for which we were not responsible exceeding the penalty is a basis for penalty adjustment, a mitigating factor, if you will. And that is our desire, and that was the purpose of that testimony.
Thank you.
Thank you. I appreciate your indulgence.
Any other questions, clarifications from commissioners on NESU number 1? Okay, seeing none, I believe we would move to any clarifications, questions around NESU consolidated.
Mr. Chair.
Yes, Commissioner Messner.
So I've got one question. I'm not sure who can answer this, but in Staff's Exhibit 200 in the complaint filed by Mr. Lackey on January 13th, 2020, he indicated that his first complaint was around November 1st to KPK. That complaint indicated that there was no growth, no corn growing, where there was contamination. And in order for there to be no growth during a growing season for corn, which I'm assuming to be between April and September, harvest being around October and November, that the field is irrigated. My question is that is there any documentation from either party of this particular site that they can share that shows the condition of this field during a growing season?
Commissioner Messner, excuse me. I guess if I understand your question correctly, you're looking for potential pictures that might exist that staff might have?
Or witness testimony that would indicate that they saw lack of corn growing in this particular site during any growing season.
And you're talking about prior to this spill report date of what says, excuse me, what says November 1st, or what we think is November 1st?
Correct.
Okay. I don't believe there is photo documentation prior to this date that is part of this particular record, but I would again direct you to the docket where a member of the Halacki family filed a public comment about this. And
I would actually, if there was documentation, any kind of photo documentation that would be available even after, I'm curious about whether or not corn is able to grow in this, even if it was after the spill date, after the repair date.
I object to the reference to the public comment by Mr. Gary Ladke
It's not a public comment. This is in the complaint itself. Exhibit
Oh,
2.
no, okay, but she just referred you to a public comment that has not been entered into evidence. And I
Part of
object.
the docket here.
It's a public comment, but it is not evidence.
And we will weigh that evidence as we will, as if it were hearsay. And so thank you, Mr. Jacobs, for the objection. Ms. Stafford, it doesn't
Thank you,
seem like
Myra.
you have any further answer to this question at this point.
No, I don't. I do not. Thank you.
Any further questions at this time?
Mr. Chairman,
Yes, sir, Mr. Jacobs.
because it's a recent event, I do want to be mindful that I believe you reminded the commissioners that the email you were sent, today or yesterday by a member of the Latke family also is not evidence and is not to be weighed as evidence. Is that correct?
And it's not even in the record, and we're
Great,
not
thank you.
considering it.
Thank you.
Yes. Okay, any questions on soil spread field? Commissioner Gonzalez?
In regards to the rule, I'm curious how staff defines construct.
Ms. Stafford, Ms. Rosenberg?
I can't speak to staff's specific factual definition, but if there's a disturbance of the native soil, that certainly factors into it.
So disturbance of the native soil to begin construction. I'm trying to understand council's argument here on how this meets, how the activities on the soil spread field meet the definition of construction of a waste management facility.
In this instance, it would be the actual act of taking the EMP waste and spreading it across. And in that scenario, that would be constructing the EMP waste management facility. It doesn't necessarily need to be, a liner placed down and walls constructed, that sort of thing.
So anytime the kind of tainted material or if that's the case, any kind of tainted material that's applied to a field is constructing a facility?
No, I don't believe that there was any evidence to say that any sort of disturbance of any type ever would be construction, but the significant disturbance of over 2 acres in this factual scenario constituted constructing an EMP waste management facility.
So I guess what I'm getting at is that the argument is that because I'm not seeing the disturbance component of it at first, right? I'm seeing kind of the spreading over is just laying over without any kind of disturbance of the underlying environment or condition or field or whatever, that staff's argument that constitutes construction.
Well, staff's argument is actually, though, that the spreading did cause a disturbance. And so that in this instance was construction, the disturbance.
Thank you for that clarification, Ms. Rosenberg.
Thank you, Mr. Gonzalez. Thank you, Ms. Rosenberg. Any other questions, clarifications around soil spread field?
Mr. Chairman, the question wasn't directed to me. I'll just remind the commission of our position that the language in the statute, before a person shall commence construction of a centralized EMP waste management facility, they'll file a form. It's our position that there is a element of intent there.
And actually, that was a question I had. How do you find the element of intent?
Because it says before a person shall commence construction, it suggests the person set out with an intent to commence construction of a centralized waste management facility rather than, for example, to plant corn. The same activity might, somebody intended to, as you know, what happened here, we contend, is we took what we thought was clean soil and put it on our property. We didn't intend to construct a waste management facility, and I don't think it's the kind of thing that contemplates accidental releases, discharges, spreading of soil. If a truck turns over on the highway, they're not trying to construct a centralized waste management facility.
And may staff offer a thought?
Yes, thank you, Mr. Mueller, for the clarification. Staff, please provide your thought.
Certainly, staff's position is that intent is not written into the rule, but staff also contends that at some point when 300 dump trucks of EMP waste that has stained soil is spread across 2 acres, that at some point willful ignorance becomes intent. And choosing to ignore something that is occurring becomes intent.
Okay, thank you, Ms. Rosenberg. All right, turning to the last matter, the Jilson number 5 flow line. Any clarifications, questions there? Okay, seeing none. And then it's not listed, but any clarification questions around the ability to pay issue from anybody? Commissioner Messner?
There's the mute button. Thank you, Mr. Chair. I wonder, and this is a question for both parties, but actually, you know what? This question was already answered for me, so I'm not going to ask this question. Thank you.
Okay. All right, before we let the parties go, any final questions from anybody? Okay, seeing none, I think at this time we will excuse the parties. I would suggest, commissioners, that we take about a 45-minute lunch break, and then we would convene back in this room for the executive session to receive legal advice on this matter from our Attorney General. I inform the participants that are looking in, so we'll come back at 12:45. We're going to go into an executive session. We're not going to make any decisions. We're going to receive legal advice. We're going to exit executive session afterward. We'll come back to this room and we will adjourn the meeting, taking no further action today. And then we would reconvene on Monday morning at 9:30 for deliberation. Did I get that right, Ms. Larson? She's nodding her head. Okay. So we'll see everybody back at 12:45 to commence the executive session. Thank you, everybody. Thank you, parties, for your presentations this morning. Very helpful. I want to thank the parties and their attorneys. You have been very respectful. You have done a good job advocating for your respective sides. And this commission thanks you for the work that you've done. So we will see you at 12:45.
Thank you.
Thank you.
Hey folks, sorry, I'm a little late. My computer decided it was time to reboot. So I am now back here. We're waiting on Karen. And I'm also still eating lunch, so apologies. Mr. Jacobs, Ms. Stafford, are you with us?
President accounted for, Mr. Chairman.
Yes, I'm here.
Okay. AAG Davenport informs me that perhaps Commissioner Nanjapa has a discrete question for a witness of each of you. Commissioner Nanjapa, do you want to alert them to the question? I'd rather, if it's possible, get that done like right now, as opposed to waiting until later. But I don't know about witness availability. So Commissioner Nanjapa, if you want to go ahead and speak up, then we can see what the next step would be.
Okay, thank you very much, Mr. Chair. And yeah, apologies. When the questions were coming up earlier and the questions that related to whether it was for the council or whether they were evidentiary, I wasn't sure if it was the right time to ask questions of other witnesses. So apologies for bringing this out a little bit late perhaps. But I did have a question for Dr. Gintatis, and then also a question for either Mr. Stoltz or Mr. Weiss with respect to ability to pay. And if possible, I had one of my requests from yesterday at the end of the day. I just wanted to clarify that as well, if that would be okay. And that, I guess, specifically for KPK, that was with respect to the average production in the past 3 years. I wanted to clarify, if possible, I'd like to exclude 2020, so the prior years, just because 2020 was a abnormal year.
If I may, Mr. Chairman, seek some clarification.
Go ahead, Mr. Jacobs.
Commissioner Nanjapa, thank you. So last 3 years, 3 full years, do you want 17 through 19? Do you want partial 21?
No, I'm thinking 2016 through 2019, just to understand a little bit about the typical production.
Yes. 17, 18, 19, and full years production.
Yes, sorry. Yes.
Which, and it's just the wells, not the flow lines, as I recall, at issue in these 5 NOAVs.
Correct.
Let me work on that. Let me also ask, if I may, do you anticipate that your question of Mr. Stoltz or Mr. Weiss would require reference to the confidential business information in the schedules 1 through 6 attached to Mr. Weiss' report? Because if it would, or you anticipate that it would, I think that implicates an executive session procedure, and I just want to be clear about that.
Yeah, I suppose it would be more of an information request, or just to confirm whether that information is within what has been submitted in the unredacted versions. So we don't need to necessarily disclose specific figures, but it is a question that relates to that. So more related to, you know, if I could be pointed to where that can be found within the exhibit.
That's fine. I would also note, just briefly, and our witnesses are standing by. I may need a few minutes to just alert them to the need to Zoom in remotely for your questions, and we can get them to respond to your questions. If it is just referencing where you would find that information in those schedules, I think I'd be comfortable doing that in the public portion of the hearing and not going into executive session. And then lastly, with respect to the production for wells at issue in the 5 NOAVs, I do note that that is publicly available, and Cogcc keeps all that information, but we'd be happy to assist in pulling that together. It would probably be us just looking at what's on the Cogcc website.
Okay, fair enough. And I'm happy to just look at that myself over the weekend. But if that was something that was easily obtainable from materials that you might have had more handy,
we're happy to assist. Thank you.
Okay. Thank you, Mr. Jacobs.
Chair, if I may.
Yes.
Oh, I'm sorry, Commissioner Nanjapa.
Yes.
We are in the process of locating Dr. Gintatis for you. I think it might take a few minutes, and If it's something, again, like Mr. Jacobs was just saying, that I could potentially point you to in the record, I'm also happy to do that.
Commissioner Nanjapa?
I'm not, well, okay, I guess I can ask. I don't believe, at least from what I had just reviewed, that it is, but if it's possible that it may be. And this is in relation to the requests or the remarks from KPK with respect to the soil spread field and the date by which we should be assessing the violation and the end date, specifically with respect to the commencement of remediation. In relation to that 324AA, I was wanting to get Dr. Gintadis's thoughts with respect to whether the stockpiling addresses appropriately the protection of, let's see, what does it say specifically? The reasonable precautions to prevent the contamination of soil and surface water.
Thank you, Commissioner Nanjapa. Let me see if I can locate that for you, and in the meantime, we will try to locate Dr. Gintadis as well.
Thank you.
Mr. Chairman, I'm going to go off mic and probably off camera to make sure I can locate Mr. Weiss and or Mr. Stoltz and respond to Commissioner Nanjapa.
Show back up once you've got them, then, Mr. Jacobs.
Very good.
Thank you.
Thank you.
Same for you, Ms. Stafford. Once you've got Mr. Quintana, Dr. Quintanas, let us know. And I think we're kind of just in a holding pattern. I don't want to exit and go into the executive session at this point. I'd rather try to knock this out. So let's just all hit mute, stop video, and then once we see the attorney show back up, we'll know to get back on board. How we doing, lawyers?
Doing well. Thank you, Chair Robbins. We've been able to locate Dr. Gintatis. If we could have him elevated to a panelist, please.
And just procedurally, to the extent that a question is asked of a witness, I'll give each of you an opportunity to redirect or cross if you feel the need.
Thank you, Chair Robbins.
Thank you.
Ms. Stafford, we're not seeing him in the house.
He was just there and now he's gone. I apologize. I will keep trying.
There it is. Got it.
Good afternoon.
Hello, Dr. Gintanis. Thanks for being with us. A commissioner had, I think, a question or two follow-up for you, and that is Commissioner Nanjappa. So thanks for rejoining us. At this time, I'm going to let Commissioner Nanjappa ask her question, and there may be some follow-up from the attorneys.
Certainly.
Thank you so much, Mr. Chair, and thank you so much, Dr. Gintatis, for indulging me with this unexpected request. I am just trying to get a better handle on the activities at the soil spread field and the dates in question, specifically with respect to 324AA, Rule 324AA, with the operator taking precautions to prevent significant and adverse environmental impacts, et cetera. There has been some discussion about adjusting the end date of the violation to September 30th as when the soil began to be stockpiled to be hauled off. I wanted to get your thoughts on why that does not constitute the commencement of remediation.
The material was not removed. That is a commencement of process, but they did not remove it from the site. I mean, they just piled it up in a big pile, and while it wasn't spread out, it was simply in a pile with no, again, as far as I know, with no kind of impermeable barrier beneath it, no berms around it. That at least I was not there, but I don't believe there were any. And we've suggested a date when the material was gone from the site, so the impacts were removed. They were not removed on the date you're talking about. They haven't even started to remove them.
Thank you, Mr. Gintatis. And to your knowledge, what was the date that the removal began?
I don't have it's in the...
That probably would be in the manifest.
It is in the record. There's in the submissions, I think, that Kelly had put in, there was a spreadsheet showing my compilation of the manifests they had told us, and I simply just don't, I could spend the time looking on my, opening up a file and finding it. I just don't have it right now.
That's okay. I'm sure I can find that information. I just wanted to understand that. But and specifically, I appreciate that you noted that upon the stockpiling, to your knowledge, there was not a liner underneath.
No, I don't. They certainly never said that. Okay. I've not seen them do that at any other site, and I don't think that they did it there either. If they have records of that, they could have told us that.
If I might jump in here just for a quick moment to direct you to the record, Commissioner Nanjappa.
Please.
The exhibits Dr. Gintatis is talking about are exhibits 825 and 826.
Okay, thank you very much.
Okay. Anything further, Commissioner Nanjappa?
Not on that point, and thank you again, Dr. Gintatis, for coming back for that point.
Mr. Jacobs, do you have any cross?
Yes, I do. Thank you, Mr. Chairman. Dr. Gontadas, thank you for being available on short notice. I just have a couple of questions. You mentioned that you weren't there when the spread field removed soil was stockpiled for removal, signaling the commencement of response to the directive to get it out of there. So you don't have personal knowledge if berms were around it or not, do you?
No, I said I did not.
Thank you. Are you familiar with the enforcement guidance and penalty policy that's been discussed at some length in these hearings thus far?
In a general sense, I'm not. That's not part of the rules that I spend a lot of time looking at. No.
I would object here. I think this is beyond the scope, and I think this question is more appropriately directed to Mr. Farron, if anyone.
But I think it's, well, if I may, Mr. Chairman, I'm not addressing Ms. Stafford, I'm addressing the commission. May I respond to that objection?
Yes.
Thank you. I believe Dr. Gontadas, and certainly Ms. Stafford will correct me if I'm wrong, was asked whether the commencement of the remediation to remove the removed soil that had been spread at the spread field, a lot of alliteration there, was that commenced, and were there, still impacts, which quite honestly, I think is a compound question. And I just wanted to understand, because Commissioner Nanjapa is inquiring about whether the date of commencement of that work should stop the running of additional days of violation for purposes of penalty calculation, if I understand her question. Is that correct, Commissioner Nanjapa?
Yes, I'm trying to understand if that would be sufficient, the stockpiling would be sufficient to indicate that the commencement of remediation had begun.
Very good. So I do think, in light of that, it's fair for me to ask if Dr. Gontadas regularly applies that commencement of remediation language, and he just answered that he does not. He does not regularly deal with the penalty policy, and that is why I don't think Ms. Stafford's objection should be sustained.
You can ask your question if he can answer it.
Well, I did. She objected really after he'd answered it. He doesn't apply it in general.
Right. Okay. So I think the question has been asked and answered at this point in time. It's in the record, and I think we are now done with Dr. Quintanas. And thank you, Dr. Quintanas, for being with us.
You're welcome.
Oh, Ms. Stafford, did you have any questions for him?
Sorry, I had trouble finding my unmute button. No, I don't believe so.
Okay.
I do have one clarifying point for Commissioner Nanjapa, and it relates to the record and exhibits. Exhibit II is the logbook that was introduced and identified by Mr. Jeff Peterson, our roustabout supervisor, that had the entry in it on, I believe, September 10. And that is the date about which you were inquiring. So that is the exhibit I think you want to look at. And his testimony, of course.
Okay, thank you. Mr. Jacobs, did you have Mr. Stoltz available?
Not yet. I believe we should have him in another 10 or 15 minutes. I do apologize for the delay. I've tried to contact Mr. Weiss as well by cell, landline, and email. So I'm doing all I can to get a witness. They were all told to be standing by, so I'm just doing my best.
Okay, let me suggest this. Commissioner Nanjapa, can you ask Mr. Jacobs your question? And if it's just trying to find something, he might be able to help us out, and then we can move on.
Yes, thank you. And again, apologies for adding this into the mix here. What I was trying to get a better understanding of is I guess the overall margins by which KPK operates year on year with respect to having their revenues and their expenses addressed, you know, what are the margins within which they operate? And I know that should be on some of the financial information that was provided, but I was not clearly finding that. Oh, you're muted, Mr. Jacobs.
It does appear that Mr. Stoltz is with us. So I'm not sure he heard that. We may need to have you repeat that question. But if Rick, I don't know, can you hear me, Rick? You're muted. Here we go. Hi, Rick.
Hello, how are you? How's everyone doing?
We are well. Thank you, Mr. Stoltz, for reappearing before us on short notice. One of the commissioners had a follow-up question that I think is within your realm of knowledge. And so I'm going to call upon Commissioner Nanjapa now.
May I advise Mr. Stoltz just very briefly in terms of the nature of his response and the need potentially to go into executive session to protect business confidentiality, so that he might speak more generally in directing Commissioner Nanjapa to the right information in the redacted schedules attached to Greg Weiss' report.
Okay, Commissioner Nanjapa, go ahead.
Thank you, Mr. Chair, and thank you very much, Mr. Stoltz, for indulging this question and for appearing. I was trying to get a better understanding of the margins within which KPK operates year on year. So after, you know, production revenues are in and after expenses are paid, you know, what are the typical operating margins? I don't expect you to give me that figure right now, or but if that is available within the exhibits, I was looking for that and having a little trouble finding that. And so if that is something that we need to look at within executive session, that would be appropriate as well. But if it is something that is available within the exhibits, if you could just point me to it, that would be great.
There is nothing in the exhibits that's going to tell you that. I would tell you that is a very complicated answer, because depending on commodity prices, the field operations in the office can be scaled to some extent, but not completely, because you have to maintain a certain number of roustabout crews, you have to maintain a certain number of pumpers, and you have to maintain a certain number of workover rig operators. So at a point, the cost structure becomes fixed. And then secondly, you have the service company operating, and the service company has been invoicing a certain amount of revenue for us shutting in wells while other operators drill horizontal wells. So you're capturing one service revenue that you're to shut in those wells that you're having an area operator pay you to do. And we try and charge shut-in production while we shut those wells in. But then all those factors kind of then go back into, okay, how many crews are we going to run? What's current price deck? How much additional revenue is coming in from other sources to support that? So it bounces up and down, and it's interdependent on what the service company is doing for third parties and except what my production levels are. So my production levels, I keep a graph, or I keep a kind of a number that, depending on production levels, my break-even prices slide, et cetera, et cetera. I can tell you on a general level, the DJ Basin assets are profitable at the lease level. They were profitable in 2019. They were profitable in 2021. They were not profitable in 2020. And I don't know if that helps, but that's kind of
go ahead.
That I don't have a specific answer without having specific circumstances is what I'm trying to say.
Okay, thank you, Mr. Stoltz. And again, I don't know if this would be best either in executive session or if it could be separately provided, but I am interested in those margins. And just, you know, by way of background, I was formerly a director of operations in a small nonprofit. We had, you know, small margins, relatively speaking as well, but it did, you know, guide our decision making and et cetera. And so that is of interest to me with respect to the case being made for the ability to pay. And so I would like to better understand what those margins have been, understanding that 2020 was an abnormal year.
I have a graph that I could provide my counsel that they could decide if they wanted to release that in an executive session that I think would lay exactly what you're looking for out. And that's at a consolidated level. And that was based on the information as I presented it to Harper Hoffer.
Okay, and does that, does the graph show like a range of approximate value of the profit margin?
It shows, I define operating cash flow as recurring oil and gas or revenues from the company less cash expenses. And what it shows you is based on the company's consolidated expenses and those revenues, where the break-even level is given the current expense structure that the company had as of the first quarter of 2021.
Okay, and do I understand then correctly that you are generally aiming for a break-even cash flow, or are you, I mean, you noted that you were profitable in prior years, or at least in 2019 and 2021.
The leases were, the oil and gas leases, that's before the company's overhead. So that's, you have to account for the leases separately, each lease on 100% basis, because you have different owners and they are in their own ledger. And then KPK has an interest in that ledger or in that lease. That in all those interests that KPK owns then come into the company's corporate general ledger. So
Okay.
when I said the properties were profitable in 2019 and 2021, I'm talking about all the DJ Basin assets as they're operated before you then break it down into what's going on with KPK and KPK's G&A and the service companies, et cetera. It's what the working interest and the net revenue interest owners would be receiving in terms of net revenue and JIPs.
Okay. Thank you. I appreciate that information. I guess I would be interested in getting a better understanding of the actual numbers in question here on typical years. You know, on average across these leases, as it relates to ability to pay, since that is an argument you have made or that KPK is making.
And
is that something that could be provided?
I think it would be a confidential item that would be an executive session that I can pass along to council very quickly, that they can decide how best to present it.
Okay, thank you very much, Mr. Stoltz. And Mr. Chair or AAG Davenport, I'm not sure if that's something that we can address on Monday and give them a little time to get that together, or if this is something that we would need to do today.
I think if this is, if you're going to continue in this area of inquiry, I'd like to get it done now, today. Mr. Jacobs, can we have you and Mr. Stoltz consult the document in question and get back to, how long do you need before you would be able to get back to us as to whether that's releasable in executive session?
If it's just the graph to which Mr. Stoltz referred, I think that might be doable fairly quickly. And I would endeavor to get back to you here very shortly, but I need to look at it and talk with my client's general counsel and come to an understanding. If it's substantially more than that, then I would need some time.
Well, why don't we start with the graph and you speak with your client and you can remove your video and audio, and then when we see you show back up, we'll continue this discussion. Commissioner Messner has a thought as well or a question.
Mr. Chair, I'm just curious why it's important that we do this prior to our executive session. It seems like we could do our executive session and then get this information immediately after it, be able to continue to move forward here.
My only thought was I'm trying to get all the evidence in before the executive session so that we can receive legal advice. But I mean, I'm fine doing that too.
Yeah, I'm supportive of that suggestion from Commissioner Messner, just simply because I also don't want to extend our time frame here more than necessary. If that allows.
AG Davenport, do you want to weigh in?
Yeah, and I apologize. I may have to think out loud a little bit here. We need, as I'm thinking through it, we need to know if KPK, and it sounds like they do, KPK thinks it's confidential business information that needs to be discussed in executive session.
Offering.
And we need to know, I would like, as I discussed previously, to not having discussed what's in the document specifically, but put on the record in open hearing that it is confidential business information so that we establish that we have the authority to enter into executive session under open meetings law. And Mr. Jacobs, you previously discussed that it, under the CORA exceptions, is probably where you would head with that.
That's
so
correct.
Some discussion on the record. Thank you. I apologize for interrupting. Some discussion on the record before we go into executive session on that. I would also like, I think staff is entitled, as they did with the other confidential business information, to view it and determine if they agree that it's confidential business information. My understanding with the other redacted document is staff did get to see that in the unredacted document. Is that correct, Ms. Stafford?
Thank you, AG Davenport. Yes, I had the opportunity to take a look at the document, but I was the only person who reviewed it.
Okay. Well, if it's agreeable to KPK, I would like to follow that process again so that we're consistent with the process, which means KPK would have to make its own decision about whether or not it's confidential business information. Ms. Stafford and only Ms. Stafford should have an opportunity to see it and see if she agrees. We'd need an offer of proof in open hearing that we have the authority to enter into executive session. Then we could go into executive session. So that means that if we went into executive session for the purposes of receiving legal advice, we would need to come back out again at some point, have that conversation, and then go back into executive session. With all of that information in mind, I'll leave it up to the commissioners what they think the most efficient process is.
I don't know that anybody really has a preferred process here. Maybe we should go into our executive session for legal advice, and then when we're done, Mr. Jacobson, as witness, can inform us of the information, the offer of proof, et cetera, and then we can go into another executive session.
Could I have 1 minute with Mr. Jacobs, please?
Sure.
John, do you have my email?
I do not. I mean, I may, but quite honestly, I've been paying attention to this riveting exchange.
I just sent the graph.
Okay.
Mr. Chair.
Go ahead.
Whenever, Mr.
No, unfortunately, because of cybersecurity reasons, our ATP scan is in process and I cannot open your attachment for a moment. So I think I'm going to need a moment. Rick, I appreciate you're trying to expedite, but I need to talk with your general counsel about this before I can do anything. And I do think that it makes more sense, Mr. Chairman, for you to enter your first planned executive session. How long do you think that's going to be? Can we guesstimate when you would come out and want us to be available?
Really, we can't.
Yeah, that's why sorry, I apologize.
Yeah, I think at least an hour.
Right. Well, I'm not going anywhere. I'm here all afternoon and I can leave this on, but, that's not an issue if it's longer than an hour. But I need some time.
Okay, then let's just do this. Let's go into our executive session, and then in doing that, Mr. Jacobs, we'll be leaving this Zoom call, but we'll leave
Correct.
the Zoom call open. And when
Okay.
you see us come back, that means we're ready to talk with you and your client.
Okay.
And thanks for the ability to negotiate through these things this afternoon and for being available. We appreciate it. So with that, AG Davenport, do you have a script to read?
I do. Thank you, Mr. Chair.
Your computer logged yourself out, so.
It did. I apologize.
Point of order, just briefly for staff, please.
Yep. Go ahead.
Or would we be able to, release our witnesses for the afternoon? Do you anticipate any additional questions for our witnesses?
I do not. Does any other commissioner anticipate questions for staff's witnesses? Yep, they can be released.
Thank you. We appreciate it.
And then, Ms. Stafford, you obviously want to stay on the Zoom call because if we do go into executive session, you'll be kindly invited.
I'll be here.
Thank you.
You're welcome.
Okay, Mr. Davenport.
Thank you, Chair. Commissioners, pursuant to the Open Meetings Law, the Commission is entitled to enter into this executive session. Into executive session at this meeting for the purpose of discussing receiving legal advice pursuant to Colorado Revised Statutes, Section 24.6, 402(3)(a), Roman 2. The topics of the executive session were identified on the agenda for today. They are to receive legal advice and analysis regarding claims and penalties in the matter of staff of the Colorado Oil and Gas Conservation Commission, the KP Kaufman Company, docket number 2011-00261. Mr. Chair, I invite you to encourage a motion to enter into executive session.
So encouraged.
So moved.
Second.
We have a motion and a second to go into executive session. All those in favor signify by saying aye.
Aye.
Any opposed? All right, we will rejoin you once we are concluded with executive session. Thanks for being patient, folks.
Thank you.
Okay, I left that.
It is 3:45 in the afternoon, and we have concluded our executive session to receive legal advice. And I would ask AG Davenport what we're supposed to do next.
Thank you, Chair. Commissioners, I have a little script to read, and then we actually need to move to vote to get out of executive session to have our brief discussion before we go back into executive session for a different purpose. We're returning from executive session. During that executive session, the Commissioner received legal advice on the claims and penalties in staff of Cogcc v. KP Kaufman, docket number 2011-00261. No decisions were made in that executive session and no votes were taken. Chair, I invite you to encourage a motion to exit executive session.
I encourage a motion to exit executive session.
So moved.
Second.
We have a motion and a second to exit executive session. All those in favor signify by saying aye.
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 Okay, we are out of executive session. I think we need to elevate Mr. Jacobs to the panel at this time. Mr. Elias. Mr. Elias. Oh, it's late. Mr. Thomas. And then are we going to do offer of proof first? Does he need his witness to do that? Good afternoon again, Mr. Jacobs. Thanks for joining us. I think that the first step before we move into executive session with your client to review confidential business information is for you to make an offer of proof that will justify this move on our part. So if you want to do that, that would be great.
Happy to do so, Mr. Chairman. As per the direction of Chairman Robbins, we have prepared certain information for production in response to Commissioner Nanjapa's requests shortly after the lunch break today. They are both clearly marked as confidential business information. KPK claims this information as confidential business information within the meaning of the Colorado Open Records Act, CRS section 2472-204 sub 3, little a, Roman 4, which creates an exception to the obligation of state government custodians of information to publicly disclose that information upon request. The operative provisions of KORA on which KPK relies in claiming confidentiality of the attached items of information were provided to Assistant Attorney General Stafford so that she could review our claim and possibly object or not object to the claim of confidential business information. That is my offer of proof.
Okay, thank you very much. Ms. Stafford, do you have any objection to the offer of proof or to our moving into executive session, knowing that we would bring you with?
No, staff does not have any objection to moving into the executive session. Having only had approximately 20 minutes or so to review this, what is being claimed confidential business information, I don't know that I can make that call just yet. So I would like to reserve my objection if possible.
That's fine. I think I don't see any problem with that. We'll then go into executive session. In order to do that, the way we've been doing this, folks, is we leave this executive session and then we open a separate Zoom for the executive session, which will be recorded. And so at this time, I understand that counsel for both sides have emailed AAG Davenport, those individuals that you desire to be in the executive session. And we have alerted our hearings manager, Thomas, to that. And Mr. Thomas, I don't know if you got a mic over there, but do you have an executive session on invite that has gone to all the people that need to be involved? Huh? Is that going via email to all the parties? Okay. I've been informed that staff is working on getting an email link to each of the parties that will be involved in the executive session, but that it has not gone out yet, but it should go out very shortly. So,
Mr. Chairman.
Go ahead, Mr. Cogcc.
Just wanted to perhaps follow up on AAG Stafford's reservation. One of the documents is a chart that Mr. Stoltz described to Commissioner Nanjapa earlier this afternoon. It was provided to United States Magistrate Judge Kristen Nix in chambers, and it satisfied her that it was also eligible as CBI under FOIA, the federal counterpart to KORA, if that helps Ms. Stafford with her deliberations.
Thanks for that explanation. Ms. Stafford, I continue to allow you to reserve any objections. And so we'll just leave it at that at this point. Knowing that we're going to get this email out probably within the next 5 to 10 minutes, let's shoot for a 4 o'clock start time in executive session. And hopefully everyone will receive the email here shortly. Oh, and we can kill some time because AAG Davenport has another executive session script to read. Okay, go ahead, AAG Davenport.
Thank you, Chair. Commissioners, same process. The words will be a little bit different this time because we're relying on a different reason than we normally do for going into executive session. Pursuant to open meetings law, the commission is entitled to enter into executive session at this meeting for the purpose of questioning a witness on matters requested to be kept confidential by KP Kaufman under state law. The commission is entitled to enter into that executive session for that purpose pursuant to Colorado Revised Statutes, Section 24(6), 402, 3A, Roman 3. The topics of executive session were, I don't believe, identified on the agenda. This is a matter that came up on a relatively short notice. We are not required to put every matter on executive session if it comes up without notice. So it is okay that it wasn't on the agenda. The only place that the topics are listed at this point is in the recording. Mr. Chair, I invite you to encourage a motion to enter into executive session for the matters and purposes I just named.
So encouraged. So encouraged.
So moved.
Second.
We have a motion and a second to enter executive session along the lines as read by AG Davenport. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Seeing none, we will enter executive session. I'm looking at my email and I don't have the link yet, so everybody just be patient and hopefully we'll get that out here fairly soon. And I suppose once you get your link, that's your notice to open it up and enter executive session, and we'll see you there.
Thank you.
All right, great. I think.
And, hearings manager, if you could go ahead and promote Mr. Jacobs and Mr. Mueller as panelists.
Just getting this out. All right, commissioners. AG Kyle Davenport speaking again. We are in open session again, having returned from executive session. During that executive session, the commission conducted examination of witnesses regarding confidential business information under state law. No decisions were made and no votes were taken. Mr. Chair, we need a motion to exit executive session.
Can we get a motion to exit executive session?
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? We are out of executive session. It is 4:38. It continues to be Friday, August 13th, and we're back in our main meeting. And I believe we have concluded the business before the commission today. The only sort of slight procedural issue is that we will start Monday at 10:30 in the morning and not at 9:30, which will give commissioners a little more time during a normal business session to get prepped for the meeting on Monday. And we will reconvene at 10:30 on Monday, August 16th. And at that time, we will undertake deliberations.
Chair Robbins, might I just add one thing with respect to the executive session we just came out of?
Yes.
I did note before we went into executive session that I wanted to reserve my right to object to the information that was being presented, and I'd like to waive that now. I agree that it is CBI.
Very good. Thank you very much for that. With that, I think we're looking for a motion to adjourn until Monday morning, August 16th at 10:30 a.m.
So moved.
Second.
We have two motions, 2 seconds. With that, all those in favor signify by saying aye.
Aye.
Aye. Very good work, everybody. Thank you, council, once again for your professional approach to this. We'll see everybody Monday morning. Have a good weekend.
Thank you.
Thank you.